Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Mishegas. Ridiculous that insanus. Oy vey, Marcus. Prosaid, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. I got this new camera and it's like, I don't know, something's going on here with the settings. Can't figure it out. Like I look dark. I don't know what's going on here. Maybe I'll figure it out. Maybe I won't, but I don't know if it's supposed to like automatically adjust. It's kind of freaking me out a little bit. All right. Good morning. Good morning. And thank you so much for coming to spend part of your Valentine's Day with me. Happy Valentine's Day, everyone. Or Galentine's Day or whatever it is that you're celebrating today. Happy Galentine's Day, Valentine's Day. Wasn't the original Valentine's Day like a massacre? How fitting then that today Aidan Kearney's motion to dismiss has dropped. Thank you, Holly Johnson, for your happy Valentine's Day super chat. I appreciate you so much. How is everyone? Well, this is going to be fun. This is going to be fun. This is going to be settle in, get your drinks, get your popcorns, get your snacks, get your hydration. So we got a 42-page motion. 42-page motion to go over. Some more Betterow and Bradel bombs in this Aidan Kearney motion to dismiss. So if you've already heard about it, no spoilers, please. Spoilers will not be tolerated today because I haven't even read the whole thing. And so there's some stuff that's going to be brand new news to me. So this is going to be good. Cheryl F. gifted 5 memberships. Thank you so much, Cheryl. I appreciate you so much. To those who are randomly gifted. I almost said grifted. Those who are randomly grifted. 5 memberships. Welcome. On top, thank you for being on top of the super sticker. And another Melanie in the chat. Melanie's red pen. Oh, Melanie's red pen is here. Happy Valentine's Day. So fitting, isn't it? So fitting. Here we are. Valentine's Day massacre. Give people a chance to get in here. I got to tell you something. Couldn't sleep last night because one of you amazing viewers brought another case out of Massachusetts to my attention that has me so outraged. And I have a feeling that a lot of people in Massachusetts don't know about this case. So let me just put it out there and see if you know about it. There's a cop. Go figure. A cop. He was a Dartmouth police officer. This is, I think, Bristol County out of like Fall River. Yeah, I don't know. I feel like my screen is blue too. It's a new camera. I don't know what the hell's going on. Let me see if I change the light. Yeah, I don't know what's going on. I can't figure it out right now. There we go. How's that? But now it's like all blown out. I don't know. Bristol. Okay. Bristol County. Cop. His name is Sean Souza. Are you listening? Are you listening? Because here's what happened the other day. He did have a Fall River accent, I think, and that's the first thing that I thought about. He was a cop. He's not a cop now, but he was a cop then. Indicted for and convicted of, we can't say that word, the R word, the grape word, of his stepdaughter between the ages of 6 and 8 years old. First trial was a mistrial. Second trial was a conviction. Not only were these couple of incidents with the stepdaughter, who was between 6 and 8 years old, there was another victim who was 15 at the time, a family friend, who was also not raped, but essayed by this former Dartmouth police officer. He was a police officer when these incidents happened. First trial ends in a mistrial, hung jury in 2019. Second trial, he's convicted last October. Wait, I think it was last October. Hold on, let me go to my notes for a sec. Convicted, sentenced by Judge Sullivan in Bristol County to 10 to 15 years in prison. He was sentenced in October 3rd of 2024. He was sentenced in Bristol County. Both girls testified against him. Both girls got up and gave witness impact statements. The first girl, who was between 6 and 8 years old when this happened to her, testified in both trials. The day that we covered the Karen Reed hearing last week on February 6th, the same judge who tried the case overturned his conviction and let him out of prison. Let him out. He's out. He's out on the street. He's out on the street because the judge who actually tried the case said, yeah, he needs a new trial because you know what? We shouldn't have tried both those victims' cases together. So it wasn't fair to Sean Souza, S-O-U-Z-A. Look it up. It's not I can't find any information about it. I've got the decision. I've got the 10-page decision. There was also, apparently there's a group of bikers. They're called Bikers Against Child Abuse. And because this young girl, well, she's older now. She's, I think, maybe 21. Because she had no support, and there were so many supporters for this ex-cop in the courtroom in Bristol County, there were 3 guys sitting in the back row in black outfits who would escort this girl in and out of the courtroom. They were part of this group that I've never heard of. Have you heard of this group? Bikers Against Child Abuse, BACA. This cop, represented by Kevin Reddington, by the way, after the trial was over, after he was convicted, made a motion, let's overturn the conviction like they do in every single case. Reddington didn't even argue that it was prejudicial that these biker guys were sitting in the back. They didn't have Hell's Angels leather jackets on. It wasn't obvious. They were just dressed in black, escorting her in and out. It was not objected to during the trial. It was never objected to that both of these cases were going to be tried together. Kevin Reddington represented Jennifer McCabe. He also represents Harry Turk. We've been following the Dr. Turk case. He's a high-level criminal defense attorney in Massachusetts. He's also representing Lindsay Clancy. Reddington didn't even argue that in his motion to set aside the verdict, but the judge, a woman, I think her name is Suzanne Sullivan, that was her rationale for overturning the conviction, granting him a new trial, and he's out on the streets. So Bristol County, beware. Fall River, if you live there, I'm horrified. I want to do a show on this. I hope you're interested because I sure as hell am, because I'm mad as hell. I'm mad as hell. I'm outraged, and you should be too. Another cop being protected, maybe, but this time in Bristol County. It's horrifying. Yeah, I couldn't even sleep. I could not even sleep. And I just got the documents this morning, and I want to do a show on that next because what the duck is going on in Massachusetts? Are all the cops protected there? It reminded me so much of like the Sandra Birchmore case. And when I first started reading about it, I was wondering if perhaps that's how he met the victim. But then some of the other articles said, oh no, it was his stepdaughter And it happened during the time that she was 6 to 8 years old. I'm horrified. You should be too. I'm outraged. And this is the next thing that I'm going to start screaming about because it's outrageous. I can't even, like, it just, the fact that these two girls went through 2 trials, or at least one of them went through 2 trials, and now they're going to have to testify against this guy again whenever it is that they choose to retry him. The DA in Bristol County is so outraged. His name is Quinn. What's his name? Thomas Quinn III. The DA in Bristol County is so outraged by this. He's appealing. He was on the news. Have any of you heard about this? Because this happened the same day of the last Karen Reed hearing, which I think was February 6th. And I don't think anybody knows about it. It was like buried in the news. I know. I hope these girls are safe while this guy's walking around too. Are you kidding me? Well, that's my outrage for the day. I'm going to cover it later, assuming something on Karen Reed doesn't pop off today, because, it's Friday and who knows what's going to happen. Probably lots of things and stuff. But the first thing that we're going to go over today is, he had massive support. Can you believe it? Yeah. Oh, yes, he did. One other interesting thing a viewer also sent me. Here's how you know the world is watching. This is coming to you courtesy of Clerk Jim Clown in chat. I don't know if he's here today, but here's how you know the world is watching, because in Colorado, which is where I went to college and law school, check this out. The Colorado Bar Association Mock Trial Committee did a Colorado Bar Association 40th annual Colorado case problem, and they called the case Colorado versus Karen Snow. Here's a summary of the case in their mock trial competition, or whatever this was for. Karen Snow is accused of hitting and killing her boyfriend with her SUV and leaving him to die in the snow. There's evidence that supports that, and the lead detective claims Karen Snow admitted to hitting him. However, a defense witness claims Karen Snow didn't proclaim, I hit him, but was incredulously asking the detective, I hit him? Moreover, there's other evidence that the victim, who was it? Somebody took, the spelling is Sean Souza, Souza. Moreover, there's other evidence that the victim, a police officer, was beaten up in a fight at a police sergeant's house and was dragged outside and left to freeze in the snow, and even evidence that someone at the house that night searched how long to die in cold before the victim's body was ever found. What the duck? This is the Colorado Bar Association's mock trial case, and it is an excellent case study. And we know it's being used in other places too, because this is the Colorado High School mock trial competition. Wild, right? Because we heard David Yannetti one day say in court that Michael Marcy's hostage video is being taught in law school by a friend of his, I think, who's a law school professor, who said, he's teaching his law students, this is what you absolutely should not do if you become a district attorney, and showed the hostage video, which we rewatched the other day. Awesome, isn't it? The world is watching. People are paying attention, and it's wild. All right, we got 42 pages, so let's go. 42 pages. You can thank the Killer Bees for this. Bradle and Betterow dropping bombs. I've read some of them. I didn't even get a chance to finish the whole 42 pages before we started here this morning, but did mark up a little bit of it with my red pen. Coincidentally, docket number 69. Docket number 69 in the Aidan Kearney Commonwealth, the persecution, the Commonwealth versus the Aidan Kearney case, also in Norfolk Superior Court. What you hear may shock you, but it certainly won't surprise you. Where the First Amendment is apparently not alive and well, especially not for journalists, but Here we go. Try and save your questions because when I'm reading, it's hard. I can't really follow the chat. So here we go. This is Aidan Kearney's McCarthy/Odell motion to dismiss indictments for lack of probable cause and for the prosecutor's impairment of the integrity of the grand jury with misrepresentations of fact and law. This is redacted. I believe it was filed yesterday. Oh no, look, it was just filed this morning. It had to be redacted before they could release it to the public. Just released this morning, 9:34 a.m. So portions of it are redacted. So where you see the black, we can kind of guess what's behind it, but I don't really know. God save the Commonwealth. Now comes the defendant, Mr. Aidan Kearney, by and through undersigned counsel, and hereby moves that the court dismiss all of the 16 indictments before the court. Just a reminder that Aidan Kearney, journalist, Massachusetts resident, is charged with 16 indictments. And they are moving that these indictments, all 16 of them, be dismissed for A, lack of probable cause that a crime was committed where the charges implicate only protected speech, and B, the prosecutor's impairment of the integrity of the grand jury by misrepresenting the state of the evidence and the law before the grand jury in a manner material to obtaining the indictments in violation of Articles 1, 10, 12, and 16 of the Massachusetts Declaration of Rights and the First and 14th Amendment to the U.S. Constitution and their progeny as set forth herein. Mr. Kearney requests that each indictment be dismissed upon a written and published judicial declaration that the alleged conduct laid before the grand jury is protected speech under Article 16 and the First Amendment, and that the said grand jury presentation was rendered defective by the special prosecutor's material distortions of fact and law, which was motivated by a clear conflict of interest arising from Mr. Kearney's investigative reporting on the very individuals who are prosecuting him. Just a reminder that Ken Mello was the special prosecutor, right, who brought this to the grand jury initially. He has since been declared to be in ill health, and it has been surmised by the current special prosecutor, Robert Cosgrove, that he will not be returning to this prosecution. But as you know, he may also be called as a witness in this case. Mellow Yellow. Yeah, reporting for jury duty says Sean Souza is a disgrace to our town. Well, guess what? He's out on the streets now because the judge just let him out of prison after the same exact judge sentenced him to 10 to 15 years for the rape of his stepdaughter when she was between 6 and 8 years old. Okay, so there's that. Back to the document. This is my cursor on your screen. Please do not smash your TV and thinking it's a fly. Thank you. Yeah, and please leave your outside drama at the door. If Team Brittany's already saying that, that means she's already having to deal with it, and it's not fair. Give my mods a break today. I've already set it to like 24-hour subscriber level. Thank you. He was in prison he was sentenced in October, so not very long, because he was out on bail the whole entire time since his first arrest in 2019. All right, we'll talk about that later on a separate stream. Here's Mr. Kearney's background relevant to the motion to dismiss. Mr. Kearney is an award-winning investigative journalist who owns, reports from, and operates a number of news outlets that broadcast over the internet through YouTube, Facebook, X, and his own websites and web pages. He live streams news, investigates matters of public concern, and often breaks stories by conducting investigations into matters neglected by law enforcement before viewers' very eyes live on the air. He offers pointed An unapologetic commentary to his viewers, which number in 6 figures and cumulatively reach into the millions. He protests, urges boycotts, engages in political hyperbole, satire, rhetorical confrontation, questions investigative targets, petitions the government for redress, and exposes corruption by government officials. He practices advocacy journalism and provides in-depth, well-sourced factual reporting, often accompanied by a call to action for justice and truth. The indictments against Mr. Kearney stem from his investigative reporting on a pending murder case in Norfolk Superior Court, Commonwealth v. Karen Reed, which we are all very, very familiar with. Ms. Reed has been charged in the 2022 death of Boston police officer John O'Keefe. Thank you, Bradel and Petero, for giving Boston police officer John O'Keefe the title that he is due. And may God rest his soul. Mr. Kearney is an outspoken supporter of Ms. Reed, who strongly believes that she was framed by numerous individuals, including members of the Massachusetts State Police, MSP, who are prosecuting him, members of the MSP who are witnesses against him, and numerous civilian witnesses against Reed. Mr. Kearney's reporting on the Reed case, including his detailed series, Canton Cover-Up, has garnered national attention. At present, Mr. Kearney has published 465 articles on the case. His reporting has broken several notable developments in the case, many of which involve the very witnesses he is alleged to have intimidated. Consequently, Mr. Kearney's reporting and advocacy journalism have severely criticized the Norfolk County prosecutors and state police assigned to the Reed case, which in turn has led them to weaponize the Massachusetts witness intimidation statute against Mr. Kearney with the intent to silence his criticism of their alleged misconduct in the Reed investigation and prosecution. Then it says, indeed, and there's a whole portion that is redacted. Electronic communications illustrate the Commonwealth's intent to silence Mr. Kearney by exploiting that fundamentally flawed statute. Shortly before Mr. Kearney's arrest for months-old conduct, blank, who has referred to Mr. Kearney as an blank, outrageously and recklessly texted blank and 3 other unknown individuals. There's a footnote 1 here, which may give us a little insight into this, because while I don't see where the footnote 1 is, it remains at the bottom of the page. And footnote 1 says, Proctor has a disturbing pattern of allowing his anger and emotions to impact his professional conduct. His shocking, misogynist, and cruel attacks on Ms. Reed are well known, resulting in his suspension without pay, and may very well result in his termination from the MSP. He referred to a medical examiner on the Reed case he disagreed with as a whack job. He has referred to one of Ms. Reed's attorneys as an a-hole. He has also described his hatred of another of Ms. Reed's attorneys. I'm going to venture a guess that these messages have something to do with Proctor and perhaps 3 other unknown individuals, because we know that Proctor's text messages have been released because 2 days ago, when we went over the latest droppings in the Karen Reed case, there were some messages in there between Adam Lally and Michael Proctor on July 1st of 2024, which was after Proctor had taken the stand in the Karen Reed case, after he was completely demolished and confronted with his unprofessional and inappropriate text messages. Apparently, the same day that the mistrial was declared, July 1st, Proctor and Adam Lally were texting, and he called Alan Jackson an a-hole and said he didn't watch the closing because, like everyone, or like all of them, he was very worried about the verdict. Can't wait to see what else comes out. Here is the applicable law. The legal principles to be applied in the instant motion to dismiss indictments concern the law of A, probable cause in the grand jury, B, impairing the integrity of the grand jury by distorting the evidence in a manner affecting the indictment decision, C, witness intimidation, picketing, and their First Amendment limitations where speech is implicated, and D, conspiracy. A, probable cause to indict. The grand jury performs the dual function of determining whether there's probable cause to believe that the suspect has committed a crime and of protecting citizens against unfounded criminal prosecutions. Fundamental considerations of fairness require that a court dismiss an indictment where the grand jury receives no evidence of criminality on the part of the accused. I just want to remind all of you, if you haven't been following me for a year, because I think it was almost like maybe a year ago, I started covering this case in January of 2024. We went through most, if not all, of the pretrial proceedings that preceded the first trial. During the course of those shows, we covered the motion to dismiss the indictments against Karen Reed for a very similar situation where it was alleged by the defense that Adam Lally, during the grand jury that was used to indict her, brought in all kinds of improper evidence, and Proctor did not disclose his personal ties to witnesses. And I urge you to go back and watch that show. Maybe I'll link it below if you're interested, because so many of those arguments now in retrospect are so true. We've come to learn that they are so true. And so it was my opinion then that it should have been granted, but based on what we know now, here's the thing. Is it a pattern in the Norfolk County District Attorney's Office to, confuse the grand jury, give them improper evidence, misstate facts and law? Because that's what apparently happened here, allegedly, according to this motion. In order to obtain an indictment, a grand jury must be presented with reasonably trustworthy information sufficient to warrant a reasonable person in believing that the defendant had committed the offenses charged. Probable cause requires more than a suspicion of criminal involvement, something definite and substantial. The Commonwealth must include information to support probable cause as to each element of the offense. I'm not going to read off the case names that they're citing, but you can come back later, screenshot them, and look them up if you are so inclined. But what I would like everyone to do before we continue, and I have to turn off the air conditioning or the heat, depending on where you are, is I would ask everyone to kindly hit the like button. Helps push the video out, helps the algorithm, helps people find this very, very important First Amendment coverage in the state of Massachusetts and for journalists in Massachusetts. Although courts do not inquire into the competency or sufficiency of the evidence before the grand jury, a judicial examination of whether probable cause existed at the time of the indictment is a clear exception to that rule. Here, the First Amendment protects Mr. Kearney's speech and opinions about a matter of public concern such that there is no probable cause of criminal activity. In short, Mr. Kearney's speech is protected as a matter of law under the First Amendment and Article 16. Further, principles of third-party liability and their absence in this presentation firmly establish that the Commonwealth has failed to implicate Mr. Kearney in any supposedly criminal activity sought to be attributed to him by third-party fellow demonstrators, whistleblowers, or other internet posters or commentators. Footnote 2, which says, Mr. Kearney does not imply or believe that any of his fellow demonstrators or internet bloggers or commentators engaged in any criminal activity. In any event, he would not be responsible for any such conduct, and nowhere in the grand jury was any foundation for joint venture liability ever referenced or attempted to be established. And then they cite some cases. B, impairing the integrity of the grand jury. We do have the best mods. We do have the best mods here, Patty. You know what? Oh, okay. Disaster averted. I caught my giant iced coffee and I did not spill it on the carpet. Impairing the integrity of the grand jury. The second instance warranting judicial scrutiny of an indictment concerns whether the prosecution has misled the grand jury with false or misleading evidence or statements. In order to show that the integrity of the grand jury has been impaired, warranting dismissal of the indictments, the defendants must be able to establish that false or deceptive evidence was given to the body, knowingly or recklessly, for the purpose of obtaining an indictment, and that the presentation of the false or deceptive evidence probably influenced the grand jury's determination to hand up an indictment. Here, the prosecutor misstated the law to the grand jury and elicited improper opinion testimony from witnesses, conflated protected speech with illegal conduct, and failed to inform the grand jury about First Amendment limitations on the speech sought to be charged. Although a prosecutor maintains discretion as to whether to instruct on the law, when he does, he must refrain from erroneous statements of the law. By providing legal instructions, the prosecutor enables the grand jury to meaningfully apply the facts to the law, thus assisting the grand jury to fulfill its role as a bulwark of individual liberty and a fundamental protection against despotism and persecution. Citing a bunch of cases. Here, as will be set forth below, the cavalcade of errors and opinions presented impaired the integrity of the grand jury proceeding and warrants dismissal of the indictments. It's a cavalcade of errors. I like that. I might steal it. Cavalcade of errors. C. Witness intimidation involving speech is strictly limited to narrow exceptions in the First Amendment. Narrow exceptions to the First Amendment. The Commonwealth ignored such limitations in its presentation. The alleged witness intimidation charges concern Mr. Kearney's reporting on the Karen Reed case, including his online updates, live shows discussing the case, appearances at demonstrations, and his expressions of opinion about the conduct of certain individuals in connection with that case. The witness intimidation charges at issue depend on certain conditions precedent, such as evidence that the alleged offender intended to mislead, offer a witness anything of value, threaten, harass, and attempt to cause emotional or economic harm. However, the First Amendment and Article 16 limit these potential violations when the alleged means of the crime is a person's speech. The Constitution, quote, demands that content-based restrictions on speech be presumed invalid and that the government bear the burden of showing their constitutionality. The carve-outs where speech may be regulated are few and narrow. In U.S. versus Alvarez, the U.S. Supreme Court set forth the entire field of exceptions as follows. In light of the substantial and expansive threats to free expression posed by content-based restrictions, this court has rejected as startling and dangerous a free-floating test for First Amendment coverage. Make that bigger. Based on an ad hoc balancing of relative social costs and benefits. Instead, content-based restrictions on speech have been permitted as a general matter only when confined to the few historic and traditional categories of expression long familiar to the bar. Among these categories are advocacy intended and likely to incite imminent lawless action, defamation, speech integral to criminal conduct, so-called fighting words, fraud, true threats, and speech presenting some grave and imminent threat the government has the power to prevent. Although a restriction under the last category is most difficult to sustain. These categories have a historical foundation in the court's free speech tradition. The vast realm of free speech and thought, always protected in our tradition, can still thrive and even be furthered by adherence to those categories and rules. Here, the Commonwealth merely alleges that the Reed witnesses and investigators suffered emotional or economic harm and or were placed in fear by Mr. Kearney's exercising of his First Amendment rights to report, question, demonstrate, and advocate on important matters of public interest, including arguments advanced in the Reed case that she was framed by the very people Mr. Kearney is accused of causing emotional and economic harm. The First Amendment does not cease to protect a journalist's non-threatening opinions simply because such speech allegedly has caused economic or emotional harm to a witness or other related person under the statute. If anything, it is precisely in these situations in which the First Amendment must protect a person's right to report on and express their opinion on a matter of public concern. All right. Let me just go to the chat for a minute before we move on. Happy Valentine's Day, Jadzia. Thanks for your super chat. Happy Valentine's Day, Adam Lally's resignation. Michelle Roy, thank you so much. Good morning. Thanks for being here for 2 months. Captain Triff says we need to stop pretending cops are good people. Well, there are some good ones and there are some bad ones. I mean, I don't think we can generalize and say they're all bad. But I think, there's a lot of issues in Massachusetts. Thanks, Captain Trips. Melanie's interruptions. Thanks for your 5. Happy Valentine's Day to you too. Thanks for going over all the bombs with us. I appreciate everything you do. Thank you so much. Thank you so much. Sue says, get in touch with Jess Machado on this. I think she covered this. This group is awesome. I have friends in Illinois who do this. You mean the Bikers Against Child Abuse? That's awesome. Thank you. Duck and Tough Tiff. Yes. Please talk about this case. BACA. They call themselves BACA or BACA? BACA. Bikers Against Child Abuse. Thank you. I plan to. Every copier is dirty. There are 0 decent ones. All right, Captain Trips. Look, I got a moderator who's 25 years on the job. He's a good cop. But if you're saying in Massachusetts, just a good time to point out that those are my viewers' opinions are not necessarily mine. It's hash value, not hashtag. Thanks for the 5. Feast of St. Valentine, martyr killed for performing marriages of Christians, which was against the law. Thank you for pointing that out to us and for your super chat. Thank you for thanking me, Luna's mom, and for being here for 13 months. And K-Wags became a new member. Welcome. Hard plastic and static mannequin. Well done. Well done. I knew somebody was going to take that one, and it was you, Adam Handful. Happy Friday, all. Oh, yeah, this is going to be a long day. So settle in, kick off your shoes, get comfortable. We're here for the long haul. Sally says, can Lally get in trouble for texting with Proctor? All sounds fugazi to me. I would submit to you that, witnesses, look, Proctor is employed by technically the Nassau County. Why do I always want to say Nassau County? Norfolk County DA's office. However, in this case, he was a witness, but he was already done testifying because the jury was in deliberations. Is it necessarily improper that he texted Lally on that day? No, I don't think so. However, it opens the door to all of those messages between them because there was a familiarity there that could indicate that perhaps he had been texting him during the rest of the course of the trial, thus violating the sequestration order. Can Lally get in trouble? I guess it depends on what they find. On top, thanks for your super sticker. Donkey's noggin, off topic, but is the defense required to hand over their own evidence? Yes, there are automatic disclosure rules for the defense as well. So I'm not sure what case you're talking about. We did a whole bunch of that when we did 2 days ago, the Karen Reed motion, where in the first trial, the defense was forced to turn over their impeachment evidence before the witnesses for the Commonwealth testified, and they were all prepped on exactly what to say when the impeachment evidence came up. So, yes, they're arguing now in the Karen Reed case that they shouldn't have to turn over the impeachment evidence for exactly that reason. Erica, 2 minutes. I dated a Norfolk cop. 3 generations of corruption. Thank you, Erica, for your super chat and your thoughts. I appreciate you. Back to the document. Alleged harassment by speech, which purportedly causes another economic harm or emotional injury, which impedes or otherwise interferes with anyone connected to a proceeding or a proceeding itself, assuredly is protected speech by the First Amendment and therefore unconstitutional. Whereas here, words or expression form the basis of the alleged violation, only true threats or fighting words can be the target of the statute. Unquestionably, all of Mr. Kearney's opinions and expressions are exempt from the statute because they are not true threats or fighting words. In these circumstances, the Massachusetts Witness Intimidation Statute, GL 268, Section 13B, which we've been over many, many times, which prohibits the causing of economic or emotional harm through non-criminal speech, that is, aside from true threats or fighting words, is unconstitutional on its face and as applied to Mr. Kearney. We've talked about this witness intimidation statute a lot. And I have said it is my opinion that it is overly broad. It's more broad than any witness intimidation statute I've ever seen. And that it may be unconstitutional on its face. And that's the argument here. In Snyder v. Phelps, the U.S. Supreme Court illustrated how the First Amendment protects the speaker even where repulsive, non-threatening speech may have caused substantial emotional harm to another. There, the family of deceased Marine Lance Corporal Matthew Snyder filed a lawsuit against members of the Westboro Baptist Church who picketed near his funeral while displaying signs that said, "Thank God for dead soldiers," and F blank G troops. In reversing an intentional infliction of emotional distress judgment for the plaintiffs, the Fourth Circuit held this highly offensive and cruel speech was protected by the First Amendment, notwithstanding the distasteful and repugnant nature of the words. Furthermore, the Supreme Court has recognized that speech on matters of public concern is at the heart of the First Amendment's protection. The First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, citing New York Times v. Sullivan, 1964 case. That is because speech concerning public affairs is more than self-expression. It is the essence of self-government. Accordingly, speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. Despite the abhorrent and gut-wrenching nature of the picketing, the fact that it was peaceful, i.e., non-criminal, focused on a traditional public forum, a public street, and addressed matters of public concern, the picketers were shielded from liability for infliction of emotional distress for their speech. That is not talking about the Kearney case, that is talking about the Snyder case. In O'Brien v. Borowski, the Supreme Judicial Court addressed the Massachusetts criminal harassment statute and its inherent conflict between the protected speech of a defendant and its possible impact on an alleged victim. The court held that illegal harassment was limited to fighting words or true threats and interpreted the meaning of fear to mean fear of physical harm or fear of physical damage to property. In other words, the SJC has made it abundantly clear that an individual's claim that another's non-threatening speech has caused her to suffer emotional or economic harm, or that they are in fear of non-criminal consequences, may not be criminalized under the First Amendment. And that is a Massachusetts case from 2012. The O'Brien court decisively held that the allegedly instilling subjective... Okay, wait, let's start that again. Hold on a second. The O'Brien court decisively held that allegedly instilling subjective fear in a person does not give a prosecutor a basis to charge them. An intent to and here they're quoting from the case, the O'Brien case. An intent to cause fear, however, is less certain to be consistent with a true threat, unless we narrow what it is that must be feared. As the U.S. Court of Appeals for the Seventh Circuit noted, there are types of threats that may contain ideas or advocacy, such as a threat to picket an organization if it does not yield to a demand to take some social or political action. Such a threat may cause a fear of economic loss, of unfavorable publicity, or of defeat at the ballot box, but such fears cannot be enough to make the threat a true threat that may be prohibited as civil harassment under the First Amendment and Article 16. There is nothing in the language of the act or in its legislative history to suggest that the legislator intended fear to mean more than fear of physical harm or property damage, and such a limiting interpretation would effectuate the legislative intent to confine the prohibited speech in the act to constitutionally unprotected speech. Therefore, we narrow the meaning of fear under the act to fear of physical harm or fear of physical damage to property. That is the controlling case in Massachusetts. The Commonwealth also elicited conclusory testimony that certain complainants, such as Elizabeth Proctor and Juliana Nagel, felt, quote, threatened. Threat is a legal term as defined under Massachusetts law and requires 4 elements as set forth in the model jury instruction. Before I read those, give me 1 second. Okay. Here are the 4 elements. Threat to commit crime. The defendant is charged with having threatened to commit a crime against the person or property of another. And this is the pattern jury instructions for Massachusetts. Threatening a person with a crime against his or her person or property. A person by threatening a crime against someone else or their property is itself a crime. In order to prove the defendant guilty of this offense, the Commonwealth must prove 4 things beyond a reasonable doubt. First, that the defendant has expressed an intent to injure a person or property of another now or in the future. Second, that the defendant intended that his or her threat be conveyed to a particular person. Third, that the injury was threatened if carried out, that the injury that was threatened if carried out would constitute a crime. And fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat. So these 4 elements, all 4 must be met. It's not an and or thing. It's all 4 must be met. Defendant had expressed an intent to injure a person or property of another now or in the future, that the defendant intended that his threat be conveyed to a particular person, that if the injury that was threatened, if carried out, would constitute a crime, and fourth, that a reasonable person would fear that the person who made the threat had both the intention and ability to carry it out. Okay? And that is quoting from the Massachusetts Model Jury Instructions, revised in 2013. The third element demonstrates the lack of probable cause to sustain indictments on such a theory. Mr. Kearney's speech did not threaten injury from a crime, and therefore do not run afoul of the Borowski rule. Rather, he expressed his opinion and common sense conclusion that people who lie may experience harm, and discomfort, but he never threatened any criminal action whatsoever. In any event, under the First Amendment, even literal threats are limited as a basis for prosecution unless they constitute true threats. In Watts versus the United States, Watts, at a public rally expressing his opposition to the military draft, said, "If they ever make me carry a rifle, the first man I want to get into my sights is LBJ." He was convicted of violating a federal statute that prohibited any threat to take the life of or to inflict bodily injury, harm upon the President of the United States. The U.S. Supreme Court reversed, interpreting the statute, quote, with the commands of the First Amendment clearly in mind, end quote. The court found that Watts's speech was protected under the First Amendment because he had not made a true threat to assassinate President Johnson, but instead had indulged in mere political hyperbole. If a legal definition must be affixed, the words qualify as political hyperbole, where, in light of its context, did not constitute a knowing and willful threat and was protected speech. Thus, the offense of threatening to commit a crime only reaches cases of true threats. The term true threat distinguishes between words that literally threaten but have an expressive purpose, such as political hyperbole, and words that are intended to place the target of the threat in fear. The term true in true threats distinguishes jests, hyperbole, and other statements that in context do not convey a real possibility that violence will follow. Citing a couple of cases. Thus, Mr. Kearney's opinions may not be criminalized under a theory that he threatened anybody, because his speech clearly does not constitute true threats. Here, all of Mr. Kearney's outlandish statements set forth in the Commonwealth's presentation are well within the realm of political hyperbole, as well as satire and opinion, given the context and the conditional nature of the commentary. The Supreme Court, in NAACP v. Claiborne Hardware, set a virtually insurmountable bar protective of fiery public speech, where they found that a public threat to break necks of anyone violating an NAACP boycott was political hyperbole and within the speaker's First Amendment rights to rally his audience to his cause. Massachusetts courts have also addressed these First Amendment protections, requiring Massachusetts judges to read statutes constraining political speech consistently. And then they talk about some more cases. A statute which fails to draw this distinction. The Supreme Court held that the constitutional guarantees of free speech and free press do not permit a state to forbid or proscribe advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. A statute which fails to draw this distinction impermissibly intrudes upon the freedoms guaranteed by the First and 14th Amendments to the United States Constitution. It sweeps within its condemnation speech, which our Constitution has immunized from governmental control. The same limiting principle obviously applies here as well. There was no evidence before the grand jury that Mr. Kearney called for imminent lawless action, as opposed to engaging in satire, political hyperbole, and projected opinion. Viewed in context and in light of the arguably more direct and alarming protected statements in the case law cited above, Mr. Kearney's expression and advocacy are clearly political hyperbole, protected speech, and cannot form the basis to find probable cause that he committed witness intimidation. Put simply, Mr. Kearney did not urge imminent lawless action, and therefore the speech is protected by all the foregoing precedent. Thus, the indictments lack probable cause that Mr. Kearney committed witness intimidation. To hold otherwise will afford the government authorities prosecuting Reed carte blanche to continue their disturbing pattern of exploiting the witness intimidation statute to suppress any speech that is critical of their conduct in the Reed case in the form of dubious, content-based prosecutions. We've seen a lot of those, haven't we? Footnote 3, which says, I need a napkin. All right, give me 1 second. Okay. Footnote 3. The same prosecuting agency here has already attempted to normalize such prosecutions, bringing at least 7 such witness intimidation and related prosecutions for placing rubber ducks bearing political messages around Canton in connection with the Karen Reed murder case. Undersigned counsel has defended 5 such cases, all of which were not allowed to continue for lack of probable cause. 4 did not issue from clerk's hearings. And the final, brought directly to arraignment, was dismissed by the Stoughton court. The balance upon information and belief did not issue either. Prior to this, the Canton Police and the Norfolk District Attorney sought to prosecute the Canton 9 for demonstrating, and charges were again stopped by the court. For those of you who don't know, Canton 9 were 9 people who held up signs across the street from D&E Pizza. Is that right? You guys can correct me if I'm wrong about that. The statute as applied to Mr. Kearney plainly violates the First Amendment, which requires the court to dismiss the charges against him and determine whether a narrower interpretation saves it to conform to the First Amendment. This is exactly what the SJC noted it would do involving the closely related criminal harassment statute in Commonwealth v. Welch, and what must happen here. In Welch, the court reversed a criminal harassment conviction and noted that if it was presented in the future with a speech case that contravened the First Amendment, it would be obligated to consider the statute and narrow its meaning to only proper constitutional parameters. Footnote 4 says the court found true threats, but not 3 in number as required by the statute. And here's what the court said in Welch. We believe the legislature, in carefully crafting the statute, intended the statute be applied solely to constitutionally unprotected speech. Any attempt to punish an individual for speech not encompassed within the fighting words doctrine or within any other constitutionally unprotected category of speech would, of course, offend our federal and state constitutions. We decline to narrow the statute by engrafting onto it a savings clause or other limiting construction at this time. Should the Commonwealth attempt to prosecute an individual for speech that is constitutionally protected, we would have no hesitation in reading into the statute such a narrowing construction to ensure its application only to speech that is accorded no constitutional protection. Emphasis added. This is just that prosecution. The related witness intimidation statute at issue here flagrantly crosses the line, criminalizing unlimited speech that subjectively causes emotional harm or economic harm to a witness or other person listed under the statute. This court should dismiss the indictments, find the statute unconstitutional as applied to this case, and limit its reach to true threats and fighting words. However, it is respectfully submitted that if the court perceives any deference to an appellate court, it should certify the question to the appeals court under Massachusetts Rule of Criminal Procedure 34, finding the issue of the statute's intrusion on fundamental rights so important or doubtful as to require a determination by a higher court. D. Let's go to the chat for a second. The Watcher. Confused European over here. I watched some trials with Emily Baker where she said that normally the lead investigator sits next to the prosecutor and therefore watches the trial. So why can't Proctor? Emily's from, first of all, she practiced in California. Their laws, their rules may be different in California. And so every state has different rules of court. So our state courts are individually governed by each state. Why can't Proctor sit and watch the investigation? Well, I mean, the trial. Well, because in this case, the Karen Reed trial, there was an order of sequestration, which said that any witnesses who were to testify were not allowed to sit in the courtroom. The only exception was given for the family of the victim. And I don't know if it's called Marcy's Law in Massachusetts, but that is typically, it gives rights to the family of the victim that they are allowed to be in the courtroom, even if they are going to testify. So I don't know if Emily was speaking to California specifically, but each state makes their own rules, and hopefully that clarifies that for you. Hi, Michelle. Thank you for your super chat. Michelle, thanks for your super chat. I've lived in Massachusetts more than half my life and never seen such corruption. Will the defense try and get the black box from McCabe's car and other cars? I don't think that they would ever be able to get it. We've seen the way these Rule 17 motions go for getting third-party discovery in this case, and it was a big fight. Big fight. James Lynch is like, the prosecution wants nothing to do with Proctor. They certainly don't want them sitting at his table. And they've since said that he wasn't the lead investigator. No, he was. Yuri Buchanan was the lead investigator. He wasn't. Now he's like customer service rep / water boy / shunned. He's been shunned. D, under the picketing statute, non-criminal speech may not be used as a basis for establishing unlawful intent to influence witnesses. Only true threats and fighting words can withstand First Amendment scrutiny. Them's fighting words. The Commonwealth has abused the First Amendment through the state picketing statute, and that is General Law 268, Section 13A, by criminalizing Mr. Kearney's lawful speech and assembly in a traditional public forum, completely absent of true threats and fighting words or other criminal actions. The statute provides, Section 13A. Whoever, with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth, or in or near a building or residence occupied or used by such judge, juror, witness, or court officer, shall be punished by a fine of not more than $5,000 or by imprisonment of not more than 1 year, or both. Okay, here's the intent portion of that. I love the way that this is written because it's logically flowing. It's laying out the law, and here's the law, and here's why you can't prosecute Aidan under this law. And it's very methodically laid out and incredibly well done. So props to Bradel or Betterow or both, or whoever wrote this, because it's impressive. The Commonwealth's problem here stems not from a permitted time, place, and manner restriction, but from an overreaching attempt to A, use non-criminal speech against Mr. Kearney, for B, establishing an unlawful intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty. In the First Amendment marketplace of ideas, non-criminal speech, urging someone to tell the truth, come forward, etc., can certainly influence a juror or justice, etc., and may obstruct or impede a proceeding. For example, a witness asks for more time to consult counsel and recant his lies, or refuses to further cooperate after giving in to urgings to stop lying, or admits corruption and becomes a whistleblower. The statute's scope simply cannot be extended to non-criminal speech in a public forum without sacrificing the First Amendment. Excellent. Simply put, non-criminal speech is allowed, even permitted and encouraged, to impede, obstruct, and delay anything it may by virtue of its rhetorical force without risk of the utterances being declared crimes. The Supreme Court so ruled in NAACP versus Claiborne Hardware, where they found that the picketers, quote, may be prosecuted for their conspiracy or other violation of valid laws. But it is a different matter when the state, instead of prosecuting them for such offenses, seizes upon mere participation in a peaceable assembly and a lawful public discussion as the basis for a criminal charge. Of course, the petitioners in this case did more than assemble peacefully and discuss among themselves their grievances against governmental and business policy. Other elements of the boycott, however, also involved activities ordinarily safeguarded by the First Amendment. In Thornhill versus Alabama, the court held that peaceful picketing was entitled to constitutional protection, even though in that case, the purpose of the picketing was conceitedly to advise customers and prospective customers of the relationship existing between the employer and its employees, and thereby to induce such customers not to patronize the employer. In Edwards v. South Carolina, we held that a peaceful march and demonstration was protected by the rights of free speech, free assembly, and freedom to petition for a redress of grievances. The picketing statute is unconstitutional on its face as applied to Mr. Kearney. It must be dismissed as to each and every complaining witness under Claiborne. Stephen King couldn't write this post, says Thomas T., and that's a perfect timing because wasn't Dolores Claiborne a novel of Stephen King's? So well done. All right. Settle down. Settle down. E. The grand jury presentation failed to present evidence of a conspiracy between Mr. Kearney and Janelle Webb to commit witness intimidation. The Commonwealth charged Mr. Kearney with conspiracy to commit witness intimidation with Janelle Webb, an Avon police dispatcher who allegedly provided license plate information to Mr. Kearney, which proved that Reed murder case witness Jennifer McCabe visited the home of lead state police investigator Michael Proctor and wife Elizabeth Proctor, which flatly contradicted Proctor's claim that he did not know McCabe personally. Mr. Kearney reported this bombshell development on his live show. This meeting was of such import that it became the subject of cross-examination of Jennifer McCabe at Reed's first trial. Shout out to Janelle. Says, oh, sweetie, no. Team Brittany says Janelle has been forgotten by most. She's a true hero. Gray Space says, oh no, how dare he use normal journalist tactics? But of course, as we know, Jennifer McCabe was prepped for all of this impeachment stuff, so she was able to have a story about why she went to Michael Lang's house, why she went to Proctor's house, right? Because she knew it was coming. She saw it coming. There are 3 indictments alleging this conspiracy, listing Jennifer McCabe, Michael Proctor, and Elizabeth Proctor as alleged victims. Okay, so to break that down a little bit further, 3 of the charges pending, I think they said in the beginning there's something like 16 charges. 3 of them are for conspiracy to commit witness intimidation with Janelle Webb. Conspiracy, and the victims there are Jennifer McCabe, Michael Proctor, and Elizabeth Proctor are the alleged victims. There must be probable cause that the defendant joined with one or more persons to do something unlawful or use unlawful means for a lawful end, and that the defendant joined the agreement knowing the unlawful plan and intending to help carry it out. Mr. Kearney and Webb face an indictment for a conspiracy in search of a crime. That's awesome. Mr. Kearney, all right, let's do it again. Mr. Kearney and Webb face an indictment for a conspiracy in search of a crime. It's a conspiracy in search of a crime. It is not a criminal offense to run a license plate. Further, there's no evidence that Ms. Webb and Mr. Kearney shared the intent to intimidate any of the 3 listed complainants. Rather, the evidence before the grand jury demonstrates, if anything, what, if anything, did it demonstrate? That Webb violated a user agreement as a trained user of the system. Notably, Webb has never been arraigned or in any way brought to court for this conspiracy charge, which was handed down over a year ago. Thus, there is no other person with whom to conspire to intimidate, and no evidence Mr. Kearney intended to intimidate Jennifer McCabe and the Proctors with this newsworthy and embarrassing scoop. Well, I mean, they never brought any charges against Janelle Webb. How can there be a conspiracy? Yes, you are in the Upside Down. You are in the Matrix. You're in Narnia. Welcome to Norfolk County. Even if Miss Webb had engaged in illegal conduct, the Supreme Court holdings protecting journalistic publication of whistleblower information. Let me read that again. Even if Miss Webb had engaged in illegal conduct, the Supreme Court's holdings protecting journalistic publication of whistleblower information. There was great public importance to verifying the presence of McCabe's vehicle at lead investigator Proctor's house. 1 month prior to the incident, in late August of 2023, District Attorney Michael Marcy issued a video statement claiming unequivocally that Proctor did not know any of the witnesses, vouching for his impartiality in the Reid investigation. Well, that's what I call the hostage video, and we watched it again the other night, and that's exactly what he said. The presence of McCabe's car at the Proctor house in the evening for a social visit suggested that Proctor and McCabe collaborated their testimony. It also eviscerated DA Marcy's public statement in which he vigorously defended Proctor and McCabe. Yep, he did. Thereafter, Marcy's own office charged Mr. Kearney with a baseless charge of conspiracy in retaliation for Kearney proving the corrupt relationship. Dun, dun, dun. I got a no quack says Turtleboy and the Pentagon Papers in the same legal document. Cool. Wouldn't it be ironic, don't you think? A little too ironic. And yeah, I really do think that if Aidan Kearney, aka Turtleboy, is the one to upend First Amendment protections in Massachusetts, wouldn't it be ironic that they chose to persecute him for this? Grace Space says, her uncle watched the hostage video for the first time last night. What did he say? Did you think it was crazy as I did? Cusco says, when you have to put out a video vouching for impartiality, you just make us question the impartiality even more. Yes. Oh, yes, it does. For these reasons, Mr. Kearney's disclosure here is completely protected by the First Amendment and its progeny. I mean, no matter what you think of Aidan Kearney, Turtleboy, this is about the First Amendment. And this is about everyone in Massachusetts, not only journalists, but, think about him what you will. But I think the fact of the matter is that the Karen Reed case would not be getting the kind of attention that it's getting worldwide if it wasn't for Aidan Kearney's 465 stories on this case. Just wouldn't. Like him or not, he brought a lot of attention to it, and he's loud and made people pay attention. F. The prosecutor impaired the integrity of the grand jury by misrepresenting fact and law, soliciting opinion, and distorting the state of the evidence by selective omissions, and the indictments must be dismissed. Christopher says, in my opinion, the hostage video is a threat to Turtleboy to stop. Turtleboy basically said, duck off. It's true. It's true. Look, a lot of people don't like him. A lot of people don't like his crass language. A lot of people don't like his methods and his behavior. And I can't say that I agree with everything that he says or does. But as long as it's not criminal and it's not in some other way an exception to the First Amendment protection, he's got the right to say what he wants to say. Scott McGinnis says, I like Ian Runkle on the Bailey. I like him, but he treads lightly, calling out systemic corruption, merely calls it police incompetence, which I strongly disagree with that opinion. He's Canadian, right? He's from Canada. No shade to Canada, but people in different countries have different ways of wording things, which may not necessarily mean what we think they mean. I don't know. Prosecutors are not required in every instance to reveal all exculpatory evidence to a grand jury. However, the integrity of the grand jury proceedings has been impaired, and dismissal is warranted where the omitted exculpatory evidence would likely have affected the grand jury's decision to indict. If the grand jury were not made aware of circumstances which undermine the credibility of evidence that is likely to have affected their decision to indict, then the appropriate remedy may be dismissal of the indictment. See Odell. That's another one of Judge Cannoni's favorite cases, Odell. The withholding of a portion of the defendant's statement distorted the portion that was repeated to the grand jury in a way that so seriously tainted the presentation to that body that the indictment should not have been allowed to stand. GP Dogdrill says, I disagree. He's a defense attorney and often calls out police misconduct. He's very familiar with it. Thank you. Thank you. Ann says, I think Runkle's more about not painting all police officers with the same broad brush of incompetence. That's what I say too. Not all cops are bad, just like not all priests are bad, not all lawyers are bad, not all doctors are bad. So it's not an invitation to insult other creators. We don't stop. This has to stop. This needs to stop. Yeah, I don't tolerate that here. I don't tolerate. I'm not saying that what Scott McGinnis said in any way. It was bashing. It was not. He's entitled to his opinion. That's wrong. But when people start defaming people in the chat and stuff, we just sort of can't. I don't let that stuff sit there, and neither do the moderators. So there's that. Thank you, Las Vegas Cops TV. Not all cops are corrupt. Great time to point out that I'm going to be joining Las Vegas Cops tomorrow. Is that tomorrow already? Tomorrow at 1 p.m. Eastern. So we're going to have some stuff to talk about, and it's going to be fun. Can't wait. Thanks for coming in. Hi, Olivia. Well, here you are. Welcome, welcome, welcome. Where was I? The prosecutor's repeated selective omissions here qualify as grounds for dismissal as set forth below. Odell and its progeny required dismissal of the indictments due to the prosecution's impairment of the integrity of the grand jury proceeding. The transcript reveals the prosecutor's repeated and improper references to the conduct of others as a basis for wrongdoing by Mr. Kearney. For example, at the transcript dated December 5th, oh, they've got all the transcripts. Jennifer McCabe sweepingly asserts without evidence and speculates that Mr. Kearney is responsible for the alleged actions of others. Quote, He brings people with him. They take pictures and they stop and they yell. They take video. They send it to him. It's almost like they get rewarded, end quote. There is no basis for joint venture liability addressed anywhere in the grand jury. Yet the prosecutor repeatedly includes other group behaviors suggestive of guilt without evidence linking the behavior to Mr. Kearney. Thank you, Auntie Bev's squeaky wheels. Leave the drama out. I'm Switzerland. I'm Switzerland. I'm Switzerland. There's so many other places that you can go to talk about the drama and listen to the drama, and this isn't one of them. McCabe refers to actions of, quote, followers of Mr. Kearney and says, quote, I don't know if one of his followers is going to show up. Quote, they text me, they email me. There are repeated references throughout the testimony implicitly assigning blame to Mr. Kearney for behavior of alleged followers. At page 35 of the same volume, Miss McCabe alleged, without curative instructions, that, quote, followers of Mr. Kearney emailed her that she would be graped on her lawn and sent her sexual messages about her daughter. As deplorable as that conduct would be, if true, and I agree, the prosecutor should not have allowed that prejudicial evidence to be offered against Mr. Kearney. By allowing such prejudicial and inadmissible evidence to be received against him, the prosecutor impaired the integrity of the grand jury because such prejudicial evidence may have resulted in Mr. Kearney being indicted for the alleged actions of others. And that's right. Aidan didn't send her those messages. Jennifer McCabe even said one of his, quote, followers, or one or more, I guess, unless it's the same person who said both of those horrific things. Elizabeth and Michael Proctor did the same. See December 14th, 2023, volume, page 34, line 8. She refers to Mr. Kearney's followers sending her emails and targeting her children without a curative instruction. Page 41, line 9, Michael Proctor complains that, quote, protesters parked on his lawn and spit at his house while driving without any proof that Mr. Kearney directed such actions. Wow. I didn't know the prosecution was this flimsy. Footnote 5, Mr. Kearney reviewed the footage of the rolling rally and saw no such behavior. See affidavit of Mr. Kearney, attached here too, adopting all factual assertions herein. At the last session on December 20th of 2023, the prosecutor instructed the grand jury on the witness intimidation charge without addressing the First Amendment limitations on the alleged speech at issue. The prosecutor, can we just confirm that it was Mello who conducted this grand jury? Can somebody just confirm that for me? Was he involved in it all the way back then? He was, right? So he's the one who did this grand jury in December 2023. Just need to confirm that. Ken Mello. Yes, he was. Okay, thank you, everyone. Thank you. Love you guys. Okay, so in this case, for those of you who don't know, in the Aidan Kearney case, Michael Marcy stepped aside and said there's a conflict and therefore we need to hire a special prosecutor. And they hire this guy, Ken Mello, who is apparently in poor health right now. That is typically the time when a sitting district attorney will hire an outside special prosecutor when there's a conflict of interest. Note, or compare and contrast that with the hiring of Hank Brennan in the Karen Reed case, where they hired someone outside the office to re-persecute the Karen Reed case because nobody else in the office would touch it. It's like the hot potato of the Norfolk County District Attorney's Office. There's no conflict. There's no reason why another attorney inside the Norfolk County District Attorney's Office can't handle the retrial. And yet, Michael Marcy in his own infinite wisdom, decided it would be wise to go out and hire an outside person to come in and try the case as a special prosecutor. It's rarely, if ever, done outside of a conflict, which is really, really weird to everyone who's looked at this case that practices law. And yet here we are. The prosecutor failed to instruct the grand jury on the limits related to any alleged harassment that served as the basis of the allegations. The prosecutor failed to address the First Amendment protections, which protect speech constituting political hyperbole. Oh, thank you. Is the show already up? Maybe I'll redirect when we're done here. Las Vegas Cops tomorrow, February 15th, 10 a.m. Pacific, 1 p.m. Eastern. Be there. We'll be square. Olivia says the McAlberts document everything feverishly, yet they've no documentation of such dramatic atrocities they claim were enacted upon them. Denise Quigley says the Norfolk DA's office is a walking conflict of interest. Live, laugh, toaster bath. I'm getting good at that. Remember how you used to give me a tongue twister every time? I've been practicing. Thanks for the 5. Says, huge Stephen King fan. He would have never authored such a twisted scenario as what they are doing to Karen Reed and her supporters. Thank you for your super chat. He did not instruct the grand jury on issues related to incitement to imminent lawless action, opinion, satire, and the necessity to find true threats or fighting words wherever First Amendment speech is concerned. Instead, the prosecutor repeatedly mischaracterized Mr. Kearney's speech as actions or conduct. The omissions created a foregone conclusion of indictment and deprived Mr. Kearney of the right to have the grand jury consider the proper treatment of speech and First Amendment limitations on the prosecution. And if there are any grand jurors out there who sat on this grand jury, would you be mad? Are you mad now knowing that the district attorney or the special prosecutor or whatever the hell they call Mellow Yellow did not properly advise you on the law so that you could make a proper indictment? The prosecutor also impaired the integrity of the grand jury proceeding by eliciting improper opinion and hearsay. Kate says, there's rumor has it that Hank was not the first person asked. Others said no. Huh. Well, you say, Dark Beholder, there's no conflict of interest that we know of. Doesn't mean there isn't one. Well, but here's the thing. If there was a conflict, Adam Lally would not be sitting at that table with him. And neither would Ms. McLaughlin. That nobody from that office would be involved in the prosecution of this case. So we have to infer that they don't see a conflict. Right? Okay. Moving on. The prosecutor also impaired the integrity of the grand jury proceeding by eliciting improper opinion and hearsay. For example, the prosecutor impermissibly expressed his personal opinion that Julie Nagel was a victim. See December 19, 2023 transcript, page 3, line 2. At the end of her testimony, she is questioned about Mr. Kearney's online reporting, in which he simply exhorted Nagel to tell the truth without making any threats or issuing fighting words. Rather than present evidence of Mr. Kearney's actual intent, the prosecutor improperly asked Nagel her opinion of Mr. Kearney's intent. Quote, in your opinion, is he trying to get you to change your testimony? Answer, yes, correct. Suggesting wrongly that the context supports a witness intimidation charge. With respect to Elizabeth Proctor, see December 14th, 2023 transcript, page 26, line 3. The prosecutor, for those of you who don't know, Elizabeth Proctor is the wife of Michael Proctor. The prosecutor asked Detective Tully his opinion of Mr. Kearney's intent. Any other incidents that you feel were intimidating to Elizabeth Proctor? Asking Tully this question. That you feel were intimidating to Elizabeth Proctor? And the detective answers, without reference to any evidence from Elizabeth Proctor on the point, that Mr. Kearney was protesting to the neighborhood, giving the reader no idea whether she was, quote, intimidated by it, and whether the alleged fear experienced was within O'Brien v. Borowski or protected speech. The repeated reliance on opinion is, again, a directive from the prosecution to indict and warrants dismissal. The repeated use of multiple police officers and civilians to express their inadmissible opinion of Mr. Kearney's intent may have infected the proceeding by leading the grand jurors to credit inadmissible opinion evidence on Mr. Kearney's intent as a basis to believe that every witness shared that view of Mr. Kearney's intent. Olivia says, oh, the irony about them caring at all about influencing witnesses to change their testimony. They literally had meetings with them to make changes to their testimony so as to avoid impeachment. Yeah, we went through all of that in Karen Reed's motion, right? About how the nephew was coached to change his testimony about the steak tips, perhaps, in my opinion. And Jennifer McCabe was able to head off the meeting or the swinging by Michael Lank's house and sitting in the car. Unless she ran inside quickly to use the bathroom, maybe. Because Carrie Roberts' kid was friends with Michael Lank's kid and the wife came out. And you know, Carrie's a talker. She had a whole story about that on Direct. The repeated use of multiple police officers and civilians to express their inadmissible opinion of Mr. Kearney's intent may have infected the proceeding by leading the grand jurors to credit inadmissible opinion evidence on Mr. Kearney's intent as a basis to believe that every witness shared that view of Mr. Kearney's intent. Finally, improper opinion and hearsay testimony was used to falsely establish a conspiracy between Mr. Kearney and Avon police dispatcher Janelle Webb. The prosecution failed to present any evidence that Ms. Webb and Mr. Kearney conspired to engage in criminal conduct. Accessing the license plate was not a crime, and in any event, there was no evidence before the grand jury that Webb obtained the information with the joint intent to commit witness intimidation. Instead of seeking to introduce admissible evidence in support of this allegation, the prosecutor asked Trooper Fanning, quote, "Is it fair to say that in your opinion that she conspired with Mr. Kearney to disclose the information in those queries and to have them published online?" See December 19th, 2023 transcript, page 30, line 9 to 13. Answer, absolutely. Ipsy Dixit reminds us that, quote, "She's telling them everything. We know. Carrie's a talker, but she pales in comparison to you, darling." Truth unchecked becomes, no, a lie unchecked becomes the truth. Is that it? Is that what Hank said? A lie unchecked becomes the truth. These errors, combined with the prosecutor's erroneous instructions to the grand jury, impaired the integrity of the grand jury proceeding and renders the indictments defective. G. Taken in turn and viewed in light of the legal principles set forth above, each alleged victim's testimony fails to establish probable cause for witness intimidation, picketing with unlawful intent, and conspiracy, and the indictments must be dismissed. In their vendetta against Mr. Kearney, the dual Kearney/Karen Reed investigators were clouded by conflict of interest and desperate self-protection. Oh, that is so good. I'm going to read it twice. And I'm going to get my red pen out and highlight it. In their vendetta against Mr. Kearney, the dual Kearney/Karen Reed investigators were clouded by conflict of interest and desperate self-protection. To shut down Mr. Kearney, they invented a new crime, witness intimidation by journalism, invented unlawful intent to influence from peaceful protected speech to prop up picketing charges, and speculated that Ms. Webb conspired to intimidate when she was simply a whistleblower and Mr. Kearney was a journalist protected by the First Amendment, publishing newsworthy information. Each of these unprecedented attempts to saddle Mr. Kearney with criminal behavior was an unmitigated failure. Each alleged victim will be referenced in turn as follows. All right, get your drinks out, get your popcorn out. We're going to address each alleged victim in turn. Hold on, Dr. Betterow is all over it. Surgical precision. Bradel too. I think Bradel's a huge proponent of the First Amendment. He's been fighting for this for a long time. Scott McGinnis says, welcome to the Orwellian dystopia in Norfolk County, Massachusetts. Right, Jill. Thank you for pointing this out. That was in Florida. Jill says, I remember when the Bryan Laundry stuff was going on, people were camping outside of the Laundry family home, pleading for them to speak out. No one got charged with anything there in Florida. Nope. Tea is ready. Sarah and Schwackenhor's tea is ready. Number 1, Michael Proctor, MSP lead investigator, Karen Reed murder case. Beer can opened. Vicious SUV. The evidence relating to Trooper Proctor was that Mr. Kearney called a phone number, which was made publicly available in Reed case court filings, and it turned out to be the trooper's cell phone number. Mr. Kearney was calling numbers from witness Jennifer McCabe's publicly filed call log and was shocked, exclaiming, "Oh my God, it's Proctor." Mr. Kearney was investigating who Ms. McCabe was calling. Oh man, oh man. And now we know she was calling Proctor. But you guys know, if you were watching that episode, hold on. See message aired in real time, episode 590 on Mr. Kearney's live show, offered as a video with an exhibit 2, thumb drive, and read to the grand jury at the December 14th transcript, page 3839. Wait, how many? I thought did I misstate the number of episodes before when I said 400 and something? And is it over? It's over 590? Is it in the 600? Did I invert those numbers? 645? But like, wow. Mr. Kearney left a message seeking to ask him questions that were of public concern, stated matters of his opinion on the Reed case, employed satire and political hyperbole, 734. That's a lot of investigative journalism. Hashtag Hank has his or her popcorn. Employed satire and political hyperbole, but never uttered any threats or fighting words. Because Mr. Kearney was sharing the public court documents on his screen to analyze it for journalistic purposes, Trooper Proctor's number was seen by the audience. There was never any felonious witness intimidation, only a time-honored exercise in smart, investigated journalism. Oh, I see. Okay, so 478 is for articles. 784 is his total live streams. Those are not just Karen Reed. Okay, good. Thank you for clearing that up, Suze. Gotcha. Okay, he just numbered his live streams like that from the start. Okay, cool. Cool. Where am I? Okay, the fact that the number already published in a court filing was released does not criminalize the actions, nor does the alleged calls from third parties to Proctor's number, allegedly causing Proctor to have to get a new number. These are not legally assignable to Mr. Kearney in truth or on the evidence presented. Footnote 6. Well done. Look at this. Footnote 6. If this is a crime, the prosecutor is guilty of the same. After the indictments and Superior Court arraignment, the Commonwealth Prosecutor Mello published the cell phone numbers of Attorney Bradel and 2 paralegals assisting Mr. Kearney on the front page of a public court filing, causing the paralegals to receive vulgar and alarming text messages and Attorney Bradel to have his email account hacked and password altered after the number was used as a security entry the same evening of Mello's publication. The defendant's motion for sanctions and disqualification remains pending and on the docket. Proctor was probably about to cut up his SIM card anyway, says Cheryl. There is no evidence whatsoever of any intent to cause physical injury or property damage to Proctor within the O'Brien v. Borowski limitations or emotional or economic injury, which is unconstitutional for that matter. The speech is protected by the First Amendment. Proctor also testified about the July 2023 rolling rally protest in Canton. Or Canton. He was not home, but he testified that he observed that the MSP video recorded the rally and he viewed the footage. The MSP video recorded the rally, okay. He noted no damage to anyone's property, no testimony about any charges arising from the video recording, and a complete absence of actionable criminal behavior from demonstrators peacefully exhorting witnesses to tell the truth. I haven't seen that footage, so I don't know what it shows. Mr. Kearney was the only person charged arising from the rally. Again, selective prosecution. Were they trying to shut him up? You decide. The prosecutor craftily sought to implicitly assign blame to Mr. Kearney for vague alleged criminal conduct of third parties, allegedly spitting out their window and parking on his lawn. It is notable that no such video was introduced in the presentation, and none is known to exist from discovery. Mr. Kearney digitally recorded the rally and provides a clip from the rally where he warns about a no trespassing sign and a turtle crossing sign on Proctor's lawn. Proctor has a turtle crossing sign on his lawn? Was that intended to intimidate Aidan Kearney, or did he always have a turtle crossing sign on his lawn? I need to know. Huh. See rally clip filed under separate cover with instant motion. Proctor did it just for Aidan. Team Brittany says, I saw the sign. It's real. Jeff Sneakers Arena. You just can't make this up. It was for Aidan, says Emmy. Right. Zoe says, wait, MSP has the ability to video record something? When did this marvel of technology happen? I mean, was it inverted, the video? Questions. Huh. A lot of people remember that turtle crossing sign. They knew about the rally coming and set up cameras, says Adam Lally's resignation. Did he put the sign up in the snow? Auntie Bev Squeaky Wheels wants to know. Was it saved on the DVR? Yummy Yannetti wants to know. Proctor lied about criminal behavior and also admitted he didn't even know what Mr. Kearney was saying at the rally, and that he didn't know Mr. Kearney's motivations or intentions. Finally, Mr. Kearney has reviewed the Canton police call logs from July 22nd, 2023, and not found a single call to police to report anyone involved in the rally. There is no rational proof of any unlawful intent to influence testimony as required by the Picketing statute, only lawful First Amendment protected non-criminal speech. I don't know. I would say, if anything, that turtle crossing sign belies the fact that he was afraid of Aidan Kearney. He was probably intentionally mocking him. Same way Chris and Julie Albert were, flipping the bird from John O'Keefe's fence on his front lawn. Right? Whatever they were doing. They were straddling his fence and sending him the pictures while he was in Aruba to taunt him that they were on his lawn because they called him the get off my lawn guy, Mr. Nevercracker. Olivia says the police literally bought cameras before the rally and set them up along the route. I don't know how you get closer to entrapment than that. They knew it was going to happen, but had no police there. Little Cupcake was thinking the same. His funny little sign belies his claim of intimidation. Yeah, it does, doesn't it? McAlbert's knew it was coming because it was planned, Scott says. Yep. McCabe's and Alberts, let's say. There's no rational proof of any unlawful intent to influence testimony as required by the Picketing statute, only lawful First Amendment protected non-criminal speech. Blank also revealed the improper motives for effecting Mr. Kearney's arrest in text messages provided in discovery. In a September 3rd, 2023 group text message in discovery, blank, 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 all redacted. So that was the contents of a message that we can't access. Blank admits that his motivation for having Mr. Kearney arrested is blank, that he is employing political hyperbole and satire under the First Amendment, writing about blank and intimidating him or trying to obstruct justice is only a false pretext used to silence him. Thereafter, in a July 13th, 2023 email to blank, blank calls Mr. Kearney a blank, 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 blank. Blank called him and asked blank, which again shows that the motivation for arresting Mr. Kearney wasn't for intimidation, but for personal revenge because he didn't like the First Amendment protected public references he was making about him. I don't know, but I think maybe the redacted stuff might have something to do with the DA, Michael Morrissey. I don't know. Not quite sure, because those text messages may be under a protective order, and that is why there are redactions. That's why we had to wait till it was redacted. Sydney, get it today. Did a cop flip? Mika wants to know. I don't know. It's terrible. Better with the Irish. Thanks for the super chat. Corrupt so long. My sister was killed. The guy's third DUI offense, but not a single charge. He was the postmaster general. I'm so sorry. My family had to move because he lived down the street and had to see him every day. I'm so, so sorry that happened to you. And that was in Massachusetts. Prayers up for Better with the Irish's family. And I hope your sister rests in peace. And that's heartbreaking. Lady Zelda Kelly, thanks for your 5. Imagine being one of Jennifer McCabe's kids. Your mom will go down in history forever. The entire thing is horrific. Yes, it is. Misty and Eddie, I will save that question for when we end. So I have that there. Don't think I'm ignoring you. But thank you for the super chat. Footnote number 7, which says, in January 2025, Trooper Proctor was the subject of a state police review board inquiry facing possible termination for misconduct in Karen Reed investigation. The decision is pending as of the date of this motion. He was put on unpaid leave for months prior to the hearing. So that tells me this may have something to do with Proctor. Marcy, Proctor, I don't know. Can't speculate really because I don't have any confirmation. Can I confirm or deny? Yes, letter O's by Better O. They set up cameras along where the rolling rally would take place, but never tried to get any video footage of the night of January 29th, 2022. Thank you so much for pointing out the obvious. Right? Uh-huh. Does Alexis. Hey all. Happy Single Awareness Day. Oh, please. I think Valentine's Day is like such a Hallmark holiday. First of all, you should treat your person nicely and bring them flowers all the time anyway. It shouldn't only be like a once a year thing. And who likes to even go out to dinner on Valentine's Day? It's like the one day a year that people all of a sudden want to do something nice and go out to dinner. Be like that every day. Just be like that in general. Don't need a day for that, do we? Thank you. Thanks, Scott McGinnis. This is like Mad Libs. It's like we should have who wants to make the book of like the Mad Libs Canton edition? Like, we could have like such things in there like shock, horror, intimidation, witness. It may be great. Like a puzzle, here are the names that fit in the blanks. Proctor, Tully, Mello, Morrissey, just for 4 of them. Yes, I'm sure maybe Lindsay Gattani is in there too. Kate Peter, I don't know. Because we know a lot of those messages already came out. Thank you, Kathleen, for loving my shows. I appreciate that so much. But I think a Mad Libs edition of Canton Mad Libs edition would be a great idea. Just tossing it out there. All right. Number 2, Elizabeth Proctor, wife of lead investigator Michael Proctor. Mrs. Proctor is the wife of Trooper Proctor. Her testimony epitomizes the defective nature of the presentation by the prosecutor. Her transcript is replete with complaints about the actions of others, followers, aside from the defendant, with the implicit suggestion Mr. Kearney is legally responsible for the complained on behavior or speech, with disingenuous suggestions about Mr. Kearney's intentions when he is clearly engaging in online political hyperbole, satire, or opinion, with baseless and conclusory claims that the defendant is threatening, and again, with improper opinion. Mrs. Proctor admitted calling an online commentator's workplace. Wait, what? Hold on a second. I may need some more coffee. I may need some more coffee for this. If you weren't paying attention before, pay attention now. Mrs. Proctor admitted calling an online commentator's workplace, trying to get them fired for speaking about her husband. Oh, I'm sorry. Is there any reason why she wasn't prosecuted? What? In the grand jury transcript dated December 14th, 2023, she admits, quote, I acted out and targeted one of Mr. Kearney's followers who was coming at me online, posting, and called the employer of them. And it was obviously not the right thing to do. Oh, okay. So she said she's sorry. So that's cool. No worries. But here's the thing. You can't attribute someone else's actions to Aidan. This is even more ducked up than I originally thought. Like I had an idea that it was kind of ducked up and unfair. But I mean, call a spade here. This is just. Mr. Kearney was investigating a matter of public concern. The wife of the lead investigator in the Karen Reed case was trying to punish people exercising their First Amendment rights, commenting online about her husband's alleged corruption by getting them fired and or bullying them at work. In Mrs. Proctor's world, she may seek to inflict economic harm on whoever she wishes. But Mr. Kearney must endure a felony prosecution because he's investigating corruption and matters of public concern. Okay, so here's the thing. Aidan Kearney reported on that. And Mrs. Proctor is saying that it was true. So he wasn't reporting lies. He was reporting something that she actually admits to doing. But that's okay. Yes, I do remember this, Olivia. And I can't remember his name. But she says, remember when Morrissey dismissed the witness intimidation charges against that Dover select board member because he apologized to the police that he'd intimidated? Yeah. Yeah, I do. I do. Hi, Fairy Raven. Emma is here from Ireland, everyone. Sláinte. Blaming Aidan is like Lizzie Proctor blaming her husband for making her call people's workplaces. All right. If your comments are going to comment about dirty cops, don't generalize because I'm fueled up. Auntie Bev's squeaky wheels did 25 years on the job in New York City PD, NYPD. So please don't generalize. He doesn't like it. He's fired up already, and it's not even, well, it is a little bit afternoon. It's 1:13 p.m. Bentley is laughing his ass off. Why are we even here? This is ridiculous. Mm-hmm. Here we go. Next paragraph. In the grand jury, Mrs. Proctor continued her ill-advised campaign to punish her enemies by lying about Mr. Kearney. She stated Mr. Kearney has been threatening, and she resorts to pulling emotional strings by referencing her children. The reality, as shown in the video proffered by the Commonwealth in support, shows that Mr. Kearney expresses only his protected opinion about Proctor's actions and clearly employs protected political hyperbole and satire to underscore the seriousness of police corruption by claiming absurdly he is going to take custody of their children. When Trooper Proctor goes to jail for his misconduct. Obviously, in no rational world is this a true threat or fighting words uttered across cyberspace. Yet, with a straight face, the prosecution and the witness seek to sell the grand jury on the notion that Mr. Kearney threatened to harm my children, to take my children. Just like in Watts, Supra, the context and inherent absurdity of the claim, as well as the political and public concern on the content, all conclusively contribute to the conclusion that the speech is protected. O'Brien Supra also thwarts any prosecution here, where her fear is not of a crime being perpetrated, but again, absurdly, fear that Mr. Kearney would engage in a child custody proceeding and have custody of her kids while her husband does hard time. While her husband does hard time. The one Elizabeth Proctor indictment here for witness intimidation must be dismissed. Number 3. Listen up. Jennifer McCabe and Matthew McCabe. As you can see, I haven't redlined this, so this is a cold read for me. So I don't know what's coming, but I'm on the edge of my seat. Number 3, Jennifer McCabe and Matthew McCabe. Ms. McCabe is a Karen Reed case witness who Google searched on her phone, "How long to die in cold?" Out of the more than 4,500 searches she conducted on her phone, a defense expert found that this search was the only one ever deleted in the life of the phone. A hotly contested issue in the Reed prosecution involving a battle of experts involves the time of the search. If she performed the search at the timestamp 2:27 a.m., as is claimed by the defense, this would constitute powerful evidence of her involvement in a cover-up in the murder of John O'Keefe. The prosecution claims she entered the search after 6 a.m. at Ms. Reed's behest when Mr. O'Keefe was discovered near death in Brian Albert's front yard. See grand jury transcript of December 5th, 2023. Mr. Kearney strongly supports the defense position of 2:27 a.m. and has extensively written and reported on the issue. You guys are the funniest chat on the internet. You really are. Trooper Tully encapsulates Mr. Kearney's interactions with Ms. McCabe at page 6 to 9. Oh, and it's Tully who's talking. It's Tully who's testifying about this. And remember, in one of the Better Owed letters, Better Owed bombshells, they uncovered some text messages between Tully, Mello, Masshole Mafia Kate Peter, and the alleged victim, Lindsay Gattani. They were all texting each other, and I don't know when that was, but was it before December 5th of 2023 or after? I think it was like kind of around the same time, right? Because wasn't Aidan sort of incarcerated like right before Christmas? 2023? Right. And then what they did was, what had happened was they served Tully served Lindsay Gattani, I think it was Tully, with a subpoena to testify in front of the grand jury, but this grand jury had already concluded, hence making her a witness. But this grand jury had already concluded. Another grand jury had not yet been convened, and therefore she wasn't a witness to be subpoenaed to any grand jury because there was none. Right. It's all coming back to me now. Set them up. Wow. And this is what Trooper Tully said. Ms. McCabe spoke out over Mr. Kearney's investigation of her, texting the district attorney and the prosecutors demanding action. Oh, so now we know that text message really was to Michael Marcy. And there must be other text messages to Lally demanding action. She also sought a Stoughton District Court criminal harassment order against Mr. Kearney, but was rebuffed. And that is when Judge Walsh denied that restraining order under First Amendment grounds. And that is also the text message that was screenshotted and then sent by Michael Marcy, the district attorney, from his private email to the judges in the Stoughton court. And that text message screenshotted has someone saying, which I think we can now discern as Jennifer McCabe, I'm so angry. I know it's late, but I'm so angry that Chris didn't get it. Right? And now we know she was texting Marcy directly, apparently, because Marcy put it in his own damn email, his own ducking email to all those Stoughton judges, because Jennifer McCabe could no longer trust the Stoughton clerk's office. That, in his opinion, was something like, what did he say? Horrifying? I can't remember what he said. Enter Marcy's iCloud. This is Lottie's mom. Snoopy Snack Question is going to need a bigger popcorn button. Wow, yep. Great hit, says Scott. Another written by Jim Steinman, performed by Celine Dion. Right. It's all coming back to me now. She also sought a Stoughton District Court criminal harassment order against Mr. Kearney, but was rebuffed. Oh, so she tried to get a restraining order against Aidan, but she was rebuffed. And I guess Albert also tried to get one, and he didn't get it either, but then he did, right? Then after Marcy sent that threatening email to all of those judges in Stoughton, wasn't it all of a sudden granted, even though it had already been denied? I don't know. Don't quote me on that, but I think something as such like that happened. See clip of hearing filed under separate cover. At the hearing, McCabe showed that the case was not about witness intimidation, but about her silencing Mr. Kearney, reporting about her involvement in the murder of John O'Keefe. And they attach a clip of Jennifer McCabe asking Judge O'Malley Is there anything you could do to get him to stop blogging about me? Judge O'Malley was one of the recipients in that email from Michael Marcy. And the judge demurring and declining to issue the order on First Amendment grounds. That's what she wanted to do. She wanted to get Aidan to stop blogging about her, and that's why she needed a restraining order. Significantly, the prosecutor did not disclose this adverse decision to the grand jury, depriving them of the information that the conduct was already adjudicated to be protected speech. Oh, well, that's interesting too. Finally, it's important for the court to consider that the fact that McCabe has been protected and not charged in the case does not criminalize Mr. Kearney's reporting on her involvement. Reporters often are ahead of the story, anticipating that law enforcement will actually follow the evidence where it leads and act accordingly. Hold on one second. Talk amongst yourselves for a second. Reporters are often ahead of the story, anticipating that law enforcement will actually follow the evidence to where it leads and act accordingly. Yeah. One can only wish from your mouth to God's ears. Once again, the prosecution fails in establishing any criminal behavior on the part of Mr. Kearney. The evidence adduced shows only dogged investigative journalism with impolite or distasteful and perhaps juvenile invectives, but also involves matters of extreme public concern focused on the cover-up of a murder and the potential complicity or at least shocking incompetence of the state police. It is not unique or uncommon for a journalist to follow or confront a subject in public or to go to their door and ring the bell seeking answers to important questions. And yeah, by the way, didn't one of the reporters, local reporters from Boston 25, go to Proctor's house and he got yelled at, get off my effing lawn. Both Mr. and Mr. Proctor yelled at that investigator to get off their lawn. And I don't remember her getting charged with any witness intimidation. It is certainly not criminal on its face, and especially not when viewed through a First Amendment lens. Yet all these words and instances are repeatedly used in the prosecutor's presentation and implicitly offered as a grist for the indictment mill. Implicitly offered as grist for the indictment mill. Well done. Here, once again, Mr. Kearney never used threats or fighting words, was asked questions about her extremely suspicious behavior. He was asking questions about her extremely suspicious behavior and expressing his protected opinions on the case and the culpability of various actors. Hurt feelings are legally immaterial, and using them for indictment is unconstitutional. All of this is First Amendment protected as set forth supra, and no state statute can criminalize such speech beyond these protections. The actors may civilly sue for libel, defamation, and the like, subject to truth, First Amendment, and opinion defenses, but the realm of criminal prosecution is unavailable for non-criminal speech. And that is a distinction that needs to be made. Yeah, you may be able to sue him civilly for libel, defamation, etc., etc. And then they throw in the defenses. Truth is a complete defense for libel and defamation or slander, as is the First Amendment and opinion. But the realm of criminal prosecution is unavailable for non-criminal speech. And she wasn't even on the lawn, says you wrong. You wrong says she wasn't even on the lawn. Reporters, oh, look, he's putting it in there. Reporters address suspects and witnesses all the time, demanding, shouting, and repeatedly pressing requests for answers and whether they are guilty. Mr. Kearney did nothing above and beyond such speech. McCabe claimed to the grand jury she made Mr. Kearney aware she wanted him to stop questioning her without any supporting details. Mr. Kearney denies any such communications. See the affidavit of Aidan Kearney attached here too. McCabe is on video. See Commonwealth's grand jury exhibit when she is questioned at the, I don't know how to pronounce this. Pronounce this for me. Billerica? I don't know. You guys pronounce things weird. Billerica lacrosse game, laughing and treating the episode like a joke, and never tells Mr. Kearney not to question her. It's Billerica. Billerica. Thank you. Billerica. The Billerica lacrosse game. Thank you. I stand corrected. Billerica. Billerica. You guys are so awesome. Billerica. 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 I'm getting it, you guys. I'm getting it. I'm getting there. Canton. Billerica. In fact, Ms. McCabe shows she is not afraid or intimidated by Mr. Kearney, who she repeatedly taunts online. Oh, boy. She's been taunting him online. On May 10th of 2023, McCabe reached out to Mr. Kearney, sending him a bizarre half-naked photo saying, "Ha ha, it's your boy, John C." 20 days later, McCabe went to the Stoughton District Court on May 30th of 2023, seeking the restraining order. See docket of HPO request filed under separate cover. Okay. McCabe unsuccessfully claimed she's in fear under the statute, and then only days after, on July 1st of 2023, she again engages with Mr. Kearney online, saying, "Sorry to bother you. Have fun in Mashpee," indicating she apparently knew his whereabouts. See Jennifer McCabe's screenshots filed under separate cover. There is clearly no intimidation or emotional distress afflicting Mrs. McCabe, who initiates and enjoys wrangling online with Mr. Kearney. Wait, hold on. I may need more than coffee. Was she doing this under her own name? Was this a fake screen name? Was this through Facebook Messenger? Talk to me. What was was she under a sock puppet account? McCabe surveillance. How was she communicating with him? Was this on the cesspool of Twitter? Messenger, her name is in there, or she had a different name? Maddie Cakes. This comes in Maddie Cakes, coming in hot. Hot pipe and Maddie Cakes. It was under her own Facebook. Really? Her own account. Wow. That's bold. That's bold. She knew his whereabouts. Was she having him followed? Was she following him? How did she know that he was in Mashpee? Did she have one of her cop friends put a tracker on his car? I have questions, because it could go deeper than this even. Wow. There's clearly no intimidation or emotional distress afflicting Mrs. McCabe, who initiates and enjoys wrangling online with Mr. Kearney. McCabe, like the state police and the prosecution, only wants to use the system to silence him and will say anything to get her way. Got some more redacted things now. Look at Sydney Colin coming in and gifting 10 memberships, and all of the 10 of you who are going to be gifted. Welcome. Thank you, sweetheart. That is very, very kind and generous of you. You have to be opted into gifted memberships. I don't really know how to do that, but in that case, you could also win. It has nothing to do with me. I can't pick who gets them. Sydney Collin, you're amazing. Thank you so much. Dream, Karen Reed's Revenge. Thanks for the 10. I think Proctor's being paid. Saw something on X which indicates he may be on Maura Healy's security detail. Not verified, but I'm hard-pressed to believe he's not collecting pay from somewhere. I don't know. He's been suspended without pay, you're saying. So there's something, he's doing something for money. I mean, there were some other rumblings that he worked for some PI firm. I have no idea. I don't know. And I don't want to, spread any misinformation, rumor, or speculation. So again, my viewers' opinions are their own opinions, not my opinions necessarily. Thanks, Mike. Says happy belated birthday. Your stream that day was amazing. Thank you, thank you, thank you. Thank you all for sharing my birthday with me. We had a very fun time. And thank you all for your generosity and your kind birthday wishes. It was very, very sweet. Yummy Yannetti says I could have missed it, but could Aidan provide the video outside of D&E where Alberts and Nagels threatened him to support their lack of intimidation? Well, they haven't talked about it yet, so you didn't miss it yet. I don't know if they will because I didn't read all 42 pages before jumping on here, and we're on page 32, so we have about 10 more pages to go. So welcome to everyone who else is joining right now. Smash the like button on your way in. I promise you that the Massachusetts State Police nor Canton PD will get your DNA if you do so. Helps the algorithm help a girl out. Thank you, Dennis, for tuning in from Canada and for your super chat. Super sticker. Emma gifted a membership. So somebody else is also getting gifted a membership. Thank you so much, Emma. Thank you. Random Thoughts. Deep Thoughts by Jack Handy. That's what reminds me of Deep Thoughts by Jack Handy. Thank you, Random Thoughts for the 10. U.S. needs to develop a law like the Good Samaritan for investigating reporters as long as what they report can be proven. They provide a check and balance. Oh, wait. Oh, yeah, the First Amendment. Right. It's supposed to be a thing. Thank you. Thank you so much. And Sydney, I just addressed this. So thanks again for the 10 memberships. ProHawk VJ. I live in the town that Officer Souza was employed. Oh. Fall River. He was Dartmouth PD, right? Please highlight this egregious situation. I am aware. Please make more people aware. Yeah, you are miss. Thank you for throwing a little Yiddish in there. I was alarmed. Somebody sent me that. I want to dox her or even say her name because maybe she doesn't want me to say her name, but I couldn't sleep. I started digging into this last night. I couldn't sleep. I was looking for all the information I could find. I can't believe they just let this guy out of jail and nobody seems to know about it. It's horrifying. He raped a 6-year-old many, many times between the ages of 6 and 8. And it was his stepdaughter. Yeah. And then he was convicted. And then the judge in Bristol County just let him out of jail and said, oh, yeah, you know what? He deserves a new trial. I'm horrified. Thank you, Chastity, for gifting a membership. I'm going to do a show on that because I'm so horrified. I just can't stop thinking about it. Thank you, Sydney, for becoming a member and also for gifting all those memberships, and also Letteros by Bettero. Thank you so much for gifting a membership. Here we are getting into some more redacted things in this motion. So blankety blank, blank, blank. Blank also enjoys unprecedented access to the blank himself. She has direct text access to blank's cell phone, as shown in her impounded text message, complaining that blankety blank 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 blankety blank 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 blank. Well, I know what that is. I could fill in those blanks. Jennifer McCabe also enjoys unprecedented access to the district attorney himself, or probably says District Attorney Michael Marcy himself. She has direct text access to Michael Marcy's cell phone, as shown in her impounded text message, complaining that, I know it's really late, but Chris Albert didn't get it, and I'm really mad that Turtleboy got the documents before anybody else, because we've already seen that once before in, as such, some Bettero letters that were a public filing and not redacted. And Glenn Lake says, most of my life is redacted. So that's my best guess about what that is. But text message footnote number 8 says, anonymous, thank you. This is BACA is an amazing organization supporting child victims. This is sickening. Yeah. Yeah. I'm sickened. I am sickened. Thank you. Thank you for validating my illness over this. And I can't believe that it's being hidden, just like the Penny McGee persecution was being hidden. So many people in Massachusetts didn't even know about Brian Camp being persecuted either. So I don't know what's going on over there, but your local media doesn't want to tell you any of this stuff, because the stories that I found were on little news stations that may have been more local to Fall River. Maybe they were from Rhode Island. It's not so publicly out there. If you are aware, let's do this, because I just want to take a little bit of a poll in the chat without putting a whole poll up, because that takes too much time. If you are aware of the Sean Souza case and the fact that he was let out of jail after being convicted and sentenced to 10 to 15 years in prison for not only graping his stepdaughter between the ages of 6 and 8, but also molesting another girl. If you are aware of that, put a 1 in the chat. And you're aware that he was let out of jail last week and granted a new trial by the same judge who tried him for grounds which his attorney Reddington didn't even argue. Put a number 2 in the chat if you've never heard of this case before. And put a number 3 in the chat if, yeah, I heard about it. I knew he was convicted, but I didn't know they let him out of jail. All right. 1, you know about it. You know he was let out of jail. Number 2, never heard of it. Number 3, yeah, I heard about it. I heard about his conviction, but I didn't know they let him out. A lot of people don't even know about it at all. And a lot of you probably live in Massachusetts and you're horrified. So 1 would be the only proper answer for, yeah, I know all about it. And there's not a lot of 1s in the chat. There's like maybe 3, 4. I'm not shutting up. I'm just not going to shut up about it. Okay. Look, double M, double 9 says, never heard of it. I'm from Massachusetts and I work in law enforcement. This guy, Sean Souza, was a Dartmouth cop. They put him on leave once these allegations came out, and he was indicted in 2019. First trial ended in a mistrial. Second trial, convicted. He was convicted in October. He was just let out of jail last week. Same day we were handling Karen Reed's hearing on February 6th. Oh, and you know, because Jess Machado reported on it. Well, there you go. Thanks, CM Libby. Doing the Lord's work. Did she report on it recently when he just got out of jail too? I'm not on Twitter, so I don't see a lot of stuff. Somebody sent this to me via email. Horrible. And look, you wrong. It's from Massachusetts and never heard of it. See? Yeah, it's shocking. All right, back to the McCabes. Hold on. Where was I? Okay, so that was my guess as to what that text message, what that redaction is. Mrs. McCabe's wishes are clearly a motivating factor in the improper effort to silence Mr. Kearney through these unlawful indictments. In any event, a reporter pursuing witnesses on matters of public concern is entitled to keep trying as long as he engages in lawful conduct and his non-criminal efforts to do so are protected under the First Amendment. At the rolling rally, McCabe admitted she did not call the police and suffered no damage or criminal conduct against her. See the grand jury transcript. Where Mr. Kearney engaged in non-criminal speech and was covering matters of public concern, there could be no witness intimidation or unlawful intent. Jennifer McCabe's husband, Matthew McCabe, is also a supposed victim of witness intimidation and picketing with unlawful intent from the same encounter with Mrs. McCabe and from the July rolling rally. See December 5th, grand jury transcript, page 37. A view of the confrontation at the Bill Ricca lacrosse game, cited by the prosecution and introduced within Exhibit 1, shows no threats or fighting words uttered by Mr. Kearney, but rather shows that Mr. McCabe approached and confronted Mr. Kearney and that he certainly was not intimidated by him. I've never seen that video, but Matt McCabe approached and confronted Aidan. Rather, the video clearly shows that Mr. McCabe is not intimidated in the least, that he is the aggressor and that he bumps Mr. Kearney, who is trying to ask questions, and that he greets Kearney by saying, "How's it going, tough guy? I didn't realize how small you were." Oh, but he's scared. He's wicked scared. And Bill Ricca, he's wicked scared in Bill Ricca. And then footnote 8 says this motion is blank, a redacted motion blank, omitting this information. Don't know what that is. On the issue of intent and motive on the part of Mr. Kearney, Mr. McCabe testified that, quote, I don't know what the point was about Mr. Kearney's investigative efforts at Billerica and outside court. The prosecutor asked him, do you have any sense as to why Mr. Kearney is doing this? And McCabe stated that the reasons are, quote, building his profile, building his following, and working as a mouthpiece for the defense to taint the jury pool. That's where that talking point came from. McCabe doesn't mention anything about the defendant trying to influence his testimony, even when he is led and coached by the prosecutor asking, what is his purpose directly with you? He says, we're the witnesses, but doesn't mention any perception of influence to his testimony. Oh, Maddie. Oh, Maddie McCabe, you better get your crystal light packages and you better run away because when this case gets thrown out, they're going to blame you. You screwed up, Maddie. You screwed up. You had one job. You had one job. Your one job was to tell the grand jury that you thought that Aidan was trying to intimidate you and trying to change your testimony. He was trying to influence you and that you were afraid of him. You had one job, Maddie, one job. He's going to get thrown out of, what do they call it, the little group? He's going to get thrown out of our little group, our little circle of trust, our little, no, that's from Meet the Parents or Meet the Fockers, the circle of trust. But they had that group message and it was like our little circle, our little, oh, Maddie, you're getting kicked out of the fam. Once again, it's clear that with respect to Mr. McCabe, Mr. Kearney uttered no criminal speech and is as protected against the husband as he is against the wife. Oh, is as protected against the husband as he is against the wife. Tell them the guy never went in the house. Yeah, they're here, but they're in front of the Asian house. Maddie. You had one job. You had one job. It's going to come to me, but I'm thinking of it. There's a Godfather reference here. Fredo. It's like the Fredo. He's like the Fredo of the McCabe family, right? In my opinion, totally making a reference to an old movie. And, Cuomo. Somebody called Quoto Fredo too. Regarding picketing with unlawful intent for Mr. Kearney's presence in the McCabe neighborhood at the July Rolling Rally, the allegations surrounding that episode are equally unavailing. Mr. Kearney uttered only non-criminal speech, opinion, satire, and political hyperbole. There is no criminal intent that can be found from lawful, non-threatening speech, and any contrary interpretation of the state picketing with unlawful intent statute violates the First Amendment and the case law comprehensively set forth above. Never go against the family, Andrew, never. Can't go against the family. Surprised you're not talking about all the motions that have been filed in the Karen Reed case, says that girl T. Are you talking about the ones I did 2 days ago? You talking about all the ones I did 2 days ago? There's a 4-hour stream on that. It was on my birthday. And I took care of it. It's been done. Unless there's a whole bunch coming out today. And if there are, then I don't have them in my inbox yet. So don't be surprised. You can go back and watch that one later. It's like over 4 hours long. Don't worry. It's already done. Like we're not on it. Like we're not on it here. Oh, by the way, we did it before everybody else did too. Everyone else did it yesterday, which is probably why she's confused. I love you. I'm not making fun of you or putting you on the spot in any way. I'm just saying I was on it. It was beautifully long, says Marissa. Right. Like Teresa Judas, don't go against the family. Thanks, Emma. Number 4, Colin Albert. Colin Albert is the nephew of Brian Albert, the homeowner of 34 Fairview Road in Canton, where the body of John O'Keefe was found. Reed's defense has posited that Colin may have been complicit in O'Keefe's death. Colin Albert was present at the Brian Albert home, but claims that he left shortly before Mr. O'Keefe and Ms. Reed arrived. Does anybody remember what time? Anyone? Anyone? What time, Colin? Like everyone, the only thing that everyone was consistent on was 12:10. 12:10. 12:10. Oh yeah, around 12:10. Oh yeah, I left around 12:10. You left at 12:10. 12:10. It was 12:10. It was 12:10. Well scripted. 12:10. Footnote number 9. Number 9. Number 9. Oh boy, that's a long one. State police and the Norfolk DA have recently sought to prosecute the other defendants for felony witness intimidation for leaving small rubber ducks saying Colin was in the house around Canton. The same message advocated by Mr. Kearney to raise awareness and protest the corruption endemic to the Reed prosecution. All of the cases have resulted in the clerk magistrate declining to issue complaints, and one has resulted in a written decision. Judge Walsh dismissing harassment and witness intimidation charges on First Amendment grounds. Golf clap for Judge Walsh. The Walsh decision is offered as a defense exhibit filed separately in further support of the McCarthy dismissal request, wherein Judge Walsh writes, quote, "It is the view of this court, the defendant's conduct and speech, though a rather sophomoric expression of his opinion, is nonetheless protected speech. Witness intimidation and criminal harassment charges were thus rejected by the Stoughton District Court. This court should do the same here." Mr. Kearney has written and reported extensively on Colin Albert and advocates in his reporting that he was present in the home during the assault and cannot prove otherwise. See Exhibit 1, videos, Colin Albert, footnote 10. Mr. Kearney's references to the Advantage Boys and Bang Bang statements on the Colin Albert voicemail and YouTube show are impressions of those same statements by Colin Albert from an intimidating online video made by him where he physically threatens rival teenagers called the Advantage Boys. Mr. Kearney satirized the statements on the message back to Colin Albert. Bang, 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 right. As such, it is misleading and distorts the grand jury evidence for the Commonwealth to omit the original statement by Colin Albert and risks creating the impression that Mr. Kearney making these statements constitutes his own threats or fighting words. The original Colin Albert online video is offered as a defense exhibit filed separately in further support of the Odell dismissal request. Bang, 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 pull up, yatch. That's right. It is a catchy tune. All right, moving back. In the grand jury, Colin Albert testifies to alleged emotional harm, quitting the Bridgewater State football team in the circumstances because he did not wish to be a distraction, and alleges that Mr. Kearney calls him a meathead, jock, and bully. Albert is asked by the prosecutor, "Why do you think Kearney is doing this?" And Albert responds that he doesn't know, indicating he does not think it is to intimidate him as a witness. Wait, he said he doesn't think it was to intimidate him as a witness? Well, that's what you have to show, Colin. And I think it's very sad that he had to give up his football scholarship, if that's true. All of Mr. Kearney's videos offered at grand jury within Commonwealth Exhibit 1, as well as his interactions and public commentary, are protected speech under the First Amendment and cannot support the one charge brought for witness intimidation in violation of statute 268, section 13B. As stated, respecting the other alleged victims herein, causing emotional harm to the psyche of Mr. Albert, in this case, Colin Albert, is not criminally actionable if the alleged means is non-criminal speech. Yet again, the indictment fails due to the absence of true threats and fighting words, the public concern and newsworthiness of Albert's alleged involvement, and the context and distance provided by cyberspace all contribute to negate probable cause for any crime. The speech, while perhaps juvenile or offensive or the like, is non-criminal and protected as opinion, satire, and political hyperbole. Number 5, Brian Albert. Before we get to Brian, let's go to the chat. Lara Not Croft, thank you for the 10. Does anyone remember when this sort of information used to actually shock us? Yeah. Now it's just like par for the course. Every day is a new day. Thanks, Lara, for your super chat. Amanda says, I'm at work and people keep calling and interrupting the show. Happy Valentine's Day, Mel. Happy Valentine's Day, Amanda. Happy Galentine's Day. Thanks for your 5. ProHawk VJ says, I know about it. I live in Dartmouth. I'm a mom. Not okay. Yep. Nope. Not okay. That's Sean Souza. Ipsy Dixit says, I was getting the Souza case confused with the other state case, with the other state where the cop changed his plea to guilty of child rape of foster child in Winthrop, Massachusetts. Yeah, it is crazy. Moving on to Brian Albert next. Brian Albert next. Number 5. Brian Albert is the homeowner of 34 Fairview in Canton, Mass., where Mr. O'Keefe was found deceased on the front lawn. The Reed defense team contends Mr. Albert was complicit in the assault on Mr. O'Keefe and the subsequent cover-up. They further contend the investigation was severely compromised due to his status as a retired police officer. The defense also notes a litany of suspicious behavior on the part of Brian Albert, such as tearing up the floor of the basement, getting rid of the family dog. The defense expert finds to have bit Mr. O'Keefe, selling the home, not leaving the house to investigate the dead body on his lawn when so advised, and alleged inconsistent or incredible statements, etc. And that is according to the testimony of Detective Tully to the grand jury. Footnote 11 says the Commonwealth's exhibit numbering renewed, started at 1. Okay, we don't need to do that. We don't care. It's not material to what we're talking about. Thumb drive containing rolling rally video and Canton cover-up show episodes 495 and 615. Brian Albert is the alleged victim of one charge of picketing with unlawful intent. Albert made several generalized characterizations of behavior from the rolling rally, claiming that Mr. Kearney was attempting to intimidate me and saying things of a harassing nature, and, he's going to get everybody. Attempting to intimidate me, he's going to get. Albert felt intimidated and noted that Mr. Kearney also addressed him in blogs. However, as echoed in all of the other sections, the actual words spoken were not true threats as required or harassment as defined in O'Brien, Supra. Albert testified that at the rally, he was exhorted to tell the truth and was told that he was lying. Mr. Kearney never told Albert to tell the truth, but rather addressed the audience and brought awareness to Albert's involvement in the John O'Keefe murder. None of the recorded statements involving Brian Albert at the rally can be divorced of their First Amendment protection and reasonably be construed as threats or fighting words. Kate says, coming from the scariest man in Canton. Where such protected, pure non-criminal speech is the only reported basis, the First Amendment bars the state from criminalizing such speech, regardless of the hurt feelings of the alleged witness or his family. Protected words of protest uttered in public involving a matter of public concern are entitled to the most heightened First Amendment protection and cannot be made criminal, i.e., an expression of criminal intent to impede, obstruct, delay, or influence by a subservient state statute. Stated another way. Thank you, Team Brittany. That should go without saying, but we need to say it. Do not contact, harass, threaten, or dox anyone being mentioned here. Pretty please. Thank you so very much. Stated another way. If lawful protected speech impedes, obstructs, delays, or influences a proceeding or a witness, that is a lawful manifestation of a free society. A product of the marketplace of ideas and cannot be made criminal. Number 6, Juliana Nagel. Yeah, I love it. They call them the alleged witnesses, the subtle snark. This chat is unique. Called the Snark Tank. They're called the Snark Tank, and it's a competition. It's a competition here. Yeah, Kevin noticed that too. Kevin Honky, bring it. Not a single spelling mistake in this long motion. How refreshing. No, haven't found one. Not yet. Oh, Iceman's here. Iceman is here. Yeah, what do you think this is? Some 2-bit amateur operation? Of course we're still here. Of course we're still here. It's only been 2 hours and 40 minutes. We still have 5 pages. Juliana Nagel. Ms. Nagel was present at 34 Fairview Road the night of Mr. O'Keefe's death. She initially admitted to seeing a dark figure on the Albert lawn. Her involvement in the case was addressed at the July rolling rally in her neighborhood. Like Brian Albert, Ms. Nagel parroted all the conclusory keywords in the statute. She claimed, "He harassed me at my residence. He was very intimidating. I was harassed." Well, we know who prepped her, right? Same person who maybe perhaps might have asked her for the screenshots between her and her brother Ryan. Same person who it was like she was going to leave with her brother, and then Jen McCabe was like, "Oh, stay. And she was like, "Oh, I want to stay. They'll drive me home." Talk about peanut butter and jelly in the car because there was a loaf of bread in the back seat and all. And then, for the first time ever, she says at trial that she saw a blob on the front lawn that was between 5 and 6 feet long. So there's that. And remind me, chat, when was the first time Juliana Nagel was ever interviewed with regard to this case? The Karen Reed case, rather. It was like 18 months after when she said she saw a dark figure on the lawn or something. Yet when the underlying words and statements, and that was all my opinion, by the way, my opinion about who prepped her, my opinion, 16 months, was it really like 16 months? A little over a year? Something such as like that, 18 months. It was around there. It was almost 2 years later. Yeah, it was not, they didn't, interview her right away. Like they did, Katie. Had to get Katie right in. Katie McLaughlin had to get right in there. Kevin Albert. Didn't Kevin Albert arrange the Katie McLaughlin interview? Is that her name? Katie McLaughlin? The EMT? Julie Nagel, October 2022. So that was 10 months. Katie McLaughlin, the EMT, who went to high school with a girl named Caitlin Albert. Right? Mm-hmm. Trish, Judge Susan Sullivan, Bristol County, let Sousa go and others just like him. These judges need to be jailed. That's the problem, you guys. Your judges in Massachusetts are appointed. They're not elected. They're not elected like they are here. And so, I don't know. Do they owe people favors? I don't know, but I can't make sense of it. Yet, when the underlying words and statements in video are analyzed, there are no threats or fighting words, only expressions that there's a cover-up and that Ms. Nagel should come out and tell the truth. The prosecutor, again, elicits opinion testimony. So, question. So, in your opinion, is he insinuating that you lied about this? Answer, yes. He does think that, yes. Question. In your opinion, is he trying to get you to change your testimony? Yes. Correct. Only in the prosecutor's Kafkaesque worldview can telling a witness to tell the truth be a felony. Kafka has entered the chat. In reality, where there are no threats or fighting words, protected speech cannot be characterized as a crime, is not evidence of unlawful intent, and absent such evidence, the picketing with unlawful intent indictment cannot stand. Number 7, Christopher Albert. Christopher Albert is a Canton Town selectman, the father of Colin Albert, the brother of Brian Albert. Albert was out drinking at a Canton bars with the group that later left, and he went to Brian Albert's home. Oh, it doesn't say he went to Brian Albert's home. Okay. But it isn't. I wanted to point out that in his original statement, the statement that was taken of him and Julie says they were at the waterfall and they followed back to 34 Fairview. So I have questions, but just blame Proctor because he wrote down everything wrong. They're really going to throw Proctor under the bus this time, in my opinion. All right, let me start that again. Christopher Albert in this section. All right, Christopher Albert, I'm going to call him Chris, is a Canton Town selectman, father of Colin Albert and the brother of Brian Albert. Albert was out drinking at Canton bars with the group that later left and went to Brian Albert's home on the evening of Mr. O'Keefe's death at 34 Fairview Road. Albert did not go to his brother's home that evening. Well, that's what he says. Mr. Kearney has been reporting on Albert, urging him to come clean with the full story of his family's involvement in the death of John O'Keefe. Oh, I know where they're going with this. Shield and sword, shield and sword. You can't say you didn't go back to the house and then say you're a witness to anything. Oh, I get it. Maybe that's where they're going. I don't know. Urging him to come clean with the full story of his family's involvement in the death of John O'Keefe. Mr. Kearney reports and believes that Chris Albert is complicit in the cover-up. Mr. Kearney notes to his listeners that Colin Albert appears to have received special treatment from investigators and that he has a long-standing family relationship with Trooper Proctor and/or Proctor's family, which would constitute an obvious conflict of interest. Of further public concern is the status of Chris Albert as a Canton selectman and the brother of a Canton police officer. That's Kevin Albert. Chris Albert also owns a pizza shop in downtown Canton. Mr. Kearney has protested and raised awareness in downtown Canton and then reports on his findings on his live show and other online outlets. Mr. Kearney is charged with 1 count of witness intimidation involving Chris Albert. Chris Albert testified that Mr. Kearney called him and his wife in an effort to ask them questions about the Reed case and went to his pizza shop to speak with him. Chris Albert, trying mightily to touch on all the keywords such as harassment, intimidation, economic hardship, alleged actions of others, minions, as referenced by the prosecutor. Oh, minions have entered the chat. And the like. Albert was still unable to provide any evidence of true threats or fighting words employed by Mr. Kearney. Instead, the testimony and video show Mr. Kearney again practiced his protected mix of dogged investigative journalism, advocacy, pointed political hyperbole, satire, and opinion. Chris Albert's exaggerated claims that Mr. Kearney, quote, followed him, confronted him, called his phone, showed up at public meetings, etc., are normal protected things that journalists do to try to extract answers from difficult persons of interest and public concern who they believe are hiding something or advantaging themselves through their privileged positions. None of the episodes related by Chris Albert resulted in police action or arrest. Even ignoring the fact that non-criminal speech is protected even if it causes economic and emotional harm, Albert's testimony is speculative and insufficient. It is also blatantly misleading in parts. He is specifically asked by a grand juror after his testimony on the summer 2023 activity. I guess that's the rolling rally. Did they advise you to file any kind of a harassment order or anything like that? Oh, so a grand juror asked this. The grand juror asked Chris Albert, did they advise you to file any kind of harassment order or anything like that? Chris Albert replied, no, not at that particular time, no. Chris Albert did, in fact, apply for a harassment order against Mr. Kearney on September 28th, 2023 in the Stoughton court. And like Jennifer McCabe, was rejected on First Amendment grounds. Number 12, footnote 12 says, papers from Albert's unsuccessful harassment order attempt filed under separate cover. If the grand jury received a truthful answer that the conduct aired out before the body was previously found by a judge to be protected conduct, it is likely that no indictments would have issued for all of the categorically similar conduct presented as to all of the alleged victims, right? It's like it's res judicata. It's already been decided in another court, but the grand jurors weren't told about it. And therefore, the argument is that the indictments were improper because another judge has already found what he did to be protected conduct under the First Amendment. See how that works? Chris Albert's misrepresentation went entirely ignored and uncorrected by the prosecutor. The indictments should be dismissed for this misrepresentation and the following government inaction on their own. Adding Jennifer McCabe's unsuccessful, undisclosed attempt for an order from Stoughton that was also denied on First Amendment grounds removes all doubt as to that cause or course of action. And that is footnote 13, which says McCabe's unsuccessful harassment order attempt, papers filed under separate cover. Totally res judicata, or Latin, res judicata. It's already been determined by another court. Therefore, as such, you have to honor that. Collateral estoppel is another good argument there. Perhaps. Albert also complained of economic harm and, armed only with pure speculation, tried to pin it on Mr. Kearney. That's Chris Albert. There's no evidence Mr. Kearney told anyone to bother Chris Albert to do anything to affect his business. The only evidence involves Mr. Kearney advising someone to not eat or boycott Albert's pizza due to Kearney's view of the lack of cooperation and truth-telling in the Reed case. And then there's a video of Mr. Kearney in downtown Canton at the pizza shop attached. This activity and the supposed attendant economic harm inflicted is a constitutionally protected boycott as set forth in NAACP versus Claiborne, which established conclusively the right to boycott for First Amendment purposes. Ironically, the only actual evidence of economic harm to the pizza business comes from Albert's testimony on his own actions, turning away anyone who appears to be a Reed supporter and refusing to serve them. He testified to that? So he caused his own economic harm because he wouldn't give them the pizza or the chicken parm? Chris Albert's self-inflicted wound has nothing to do with Mr. Kearney's advocacy or journalism. Commonwealth's economic harm stricture is unconstitutional, and the charge must be dismissed. Moving on to Trooper Yuri Buchanan. I don't know. I'm just going to put it out there. Do you think that Yuri Buchanan could be intimidated by Aidan Kearney? I'm just saying. Yuri Buchanan is a very large, very buff, intimidating man, as is Brian Albert. Do you think that he can really say with a straight face that he's intimidated by Aidan Kearney? That's no shade to Aidan, but this is just like a little bit ridiculous, in my opinion. But, let's see. Let's see. Trooper Buchanan is a supervisor on the Karen Reed case state police team. He oversees Trooper Proctor and was himself punished for condoning and covering up Proctor's misconduct in the Reed case as set forth, supra. He has been on the DA's detective unit for almost 10 years. Buchanan alleges that on September 15th, 2023, he was the victim of witness intimidation by Mr. Kearney. Buchanan complains that on the public street outside the Norfolk Superior Court, Mr. Kearney asked him questions, and he was badgered with insults on his way to his police car. Oh my God. Really? He claims Mr. Kearney called him a pig and that the state police was ashamed he was wearing their uniform. Buchanan then reports interactions with third parties that upset him, where he and the prosecutor again create the implicit suggestion that Mr. Kearney should be held responsible criminally for this discomfort. Here, the familiar refrain in the instant memorandum again applies. Mr. Kearney's speech is protected as non-criminal First Amendment expression on matters of public concern. Expressions of disapproval of the police are protected under the First Amendment, and name-calling certainly qualifies as such. Do you know what the NYPD officers go through on a daily basis? Could you imagine if they filed charges against everyone who called them a name? In fact, the oft-cited herein O'Brien v. Borowski case is famous as the case that makes it clear that it is constitutionally protected speech to give the finger to a police officer without criminal consequence, so long as there are no accompanying actions or other criminal utterances that can create a true threat situation. Well, that's interesting. As in O'Brien, Mr. Kearney spoke disapproval to Trooper Buchanan concerning malfeasance in his official duties and also questioned him regarding an unaccounted for Ford Edge vehicle seen outside of the Albert house late at night by the plow driver. Lucky. The encounter was in public and played out in front of several state troopers doing guard duty on the crowd, as mentioned by Buchanan, and none reacted, intervened, and certainly didn't arrest Mr. Kearney for this supposed witness intimidation. This is because even inexperienced highway state troopers guarding the courthouse know that such an encounter is protected speech, lacks true threats or fighting words, and cannot solely be found to be witness intimidation. A little shade to the inexperienced highway state troopers there, just a little. Even they know it. The Buchanan indictment, brought in bad faith and with anti-constitutional motives, lacks probable cause and must fail. Yes, Cheryl, do you think Betterow cites the First Amendment? I think it's Betterow and Bradel who wrote this. I don't know who actually wrote it, but I'm going to give them both credit. Cites the First Amendment this frequently to be able to take it to the federal Supreme Court level, perhaps. Perhaps. Conclusion, for the foregoing reasons, the indictments lack probable cause and were the product of an irredeemably impaired presentation by the district attorney. All of the charges must be dismissed. Dated yesterday, 2/13. Oh, it says 05, but we know it's supposed to be 25. XOXO, Aidan Kearney, by his attorneys, Timothy Bradel, Mock Betterow, the Killabees. And it's also sworn to by Aidan Kearney, saying that he is swearing that everything in that affidavit, everything in that pleading is true and correct to the best of his knowledge. And what say you? I think it's fire. I can't wait to see the opposition by the Commonwealth. In my opinion, I can't wait to see it. What are they going to argue? Must be dismissed under its own statute and the law of the Supreme Court of the United States of America protecting First Amendment speech. Some of the witnesses didn't even testify that they were intimidated. I mean, what? Misty and Eddie, is a great question. If Lally did get called to the stand by the defense, what would the process be, if any? I cannot claim to know the Massachusetts rules of court. I would imagine they would have to subpoena him. There may be a motion to quash that subpoena. They may have to convince a judge that Lally is a fact witness and should be called to the stand. There would be some proceedings involved. They wouldn't be able to just say, Lally, please take the stand. So they would need to get like court permission. And I have questions about that, because if Lally is called as a fact witness and he's still sitting at the prosecution table, does that disqualify like the entire prosecution team? In some states it might. So I have questions about that. But yeah, that is a great question. And I just don't know 100% the answer to it. But I would imagine they would subpoena him. There'd be a motion to quash. There would have to be conversations with the judge, and it would be a big thing, a whole big thing, which is another reason why this case may not go to court, may not go to trial on April 1st. Just another reason. Did I bite him? Yeah, I bit him. Thanks for your 10. I believe that was Tarantino, Kill Bill. Spun in a spaghetti western of the Commonwealth of Massachusetts. Oh, happy Valentine's Day to you too. And thank you for super chat. Tracy's asking me if Buchanan is a Marine. I don't know. I don't know. Is he? No, did I read that he was a Marine and I didn't absorb that information? I don't know. Semper Fi. Does anybody know? David's like, I'm not sure. Do you think you could go all over all of that again? No, I can't. But you can always rewind it. You can always rewind it. Thank you, Emma, for the matcha latte. I appreciate you. You can always rewind it and watch it again. Sometimes you have to watch it like 4 or 5 times before you can get like the true understanding of everything. That was 42 pages of fire. Thoughts, comments, questions, concerns. Yes, he's former military, but I don't. People say he was military. I don't know. Thought that came out on the stand. I don't. Tracy, you're really testing my memory now. I have questions. Says I'd love to see any proof at all that they even attempted to find who owned that Ford Edge. Like even them looking up the DMV records for dark Ford Edges in Kearney. Well, a lot of people in that family own Ford Edges. It's been pointed out before. Colin Albert drives one. Brian Higgins had one. I don't know. Did the Alberts have a Ford Edge too? I don't even know. But there were a lot. There are a lot of Ford Edges in that family. And they're also used, I think, as, I don't know, they use as police vehicles too. I don't know. I don't know. Katrina says, I don't know how much defense would bother to waste their time with Lally. Couldn't they get that in with Cross or Proctor? Well, no, I'm talking about where'd you get that Sallyport video from, Mr. Lally? When's the first time you were provided with that? Who gave it to you? There's a lot of questions for Lally. A lot of questions. And they've demanded in the Karen Reed case, all text messages between anybody who works for the Norfolk County DA's office, text messages, emails, voice messages, anybody who works for that office, including law enforcement, because they also are imputed to work for the Norfolk County DA's office, and any witnesses in this case, not just the ones that they pointed out during that motion, like the text messages between Proctor and Lally, and the text messages. There were some other text messages that they pointed out in that motion as well. That wasn't the only example that they gave. So we'll see. Yeah. Grace Bay says even Jerry Holman, this is in the Delphi case, eventually looked up how many black Ford Focuses there are in Carroll County, Indiana. Kevin Albert has a Ford Edge, says Jenny. I don't know, Aaron. Did they have a deal with the local Ford dealership? I don't know. I don't know. It's a good question. The Alberts have lost their edge, says Glen Lake. How much freaking out do you think is going on today? PCM says, I think that's the only reason Lally is still on the prosecution team, to help prevent him from being called to testify. I don't think it's going to prevent it, though. I don't think he can hide behind it. I don't think he can hide behind it. Crystal says, I like how you ask thoughts, questions, and concerns. This whole thing is a concern. This whole thing is a concern, in my opinion. It's my opinion. I'm sticking to it. Wasn't Yuri investigating his own intimidation case out? No, I think he intimidated some other people. No, I think he was investigating other alleged intimidation cases. That's what it was. It was text messages between Chris Albert, right, and Yuri Buchanan, saying there's some women outside my shop taking pictures, which is fine, but I have video of it. And then one of the women put her hand to her head like a gun, and I have video of it. And Yuri said, email it to me. And he said, okay, I will, as if he had his email address and they had been in contact for many. So that's what it was. Thank you for reminding me of that. Those were the other text messages that were referred to in the Karen Reed motion that we went over, or motions that we went over for 4 hours on Wednesday. Let me just check something in the docket. It is my opinion that these are very good arguments against the constitutionality of the Massachusetts witness intimidation law and its selective persecution and First Amendment as such. What a judge will do with this, I don't know. I don't know. Because again, we're in Massachusetts. Is it ripe for appellate issues? Absolutely. Should the judge follow what all the other judges did? I mean, listen, if they couldn't get restraining orders because there was nothing done to intimidate them, doesn't that go to prove the truth of all of these matters asserted? Okay, so wait, docket 500, that there's nothing new been filed today yet in the Karen Reed case. Which judge is hearing this case? I want to say Doolin. And I want to say that the hearing for this motion to dismiss is going to be March 5th, which is also a date for the Karen Reed trial for, I think, motions in limine. So they're both going to be on the same day. And that is crazy. Crazy, in my opinion. Thoughts, questions, comments, concerns before we wrap this 3-hour stream today, because I have to go off the air and then have a little snack or lunch or something, and then who knows, because things always pop up right before 5 o'clock on a Friday. So you want to make sure that you've got your notification bell set for all of the notifications, because a lot of times I just go live, like spur of the moment type things. And also, you don't want to miss it, because if I don't give a half an hour of notice, you might not even get a notification. So you just kind of got to try and do it like more than a half an hour in advance so that you can get notifications. But it doesn't always work that way, especially during breaking news. And so much is breaking on this case constantly, it feels like. Hang on a second. Hold on. LV Cops, what's the name of your channel? I want to redirect for tomorrow. Is it LV Cops? But I can't find it. Hold on. LV Cops TV, is that the name of it? Hold, please. LV Cops TV, if you don't allow redirection, I can't redirect to the show for tomorrow. Is it up? All right, it's up for tomorrow. It's at 1 p.m. But if you guys don't allow redirection, then I can't redirect. So hold on a second. Let me just see. That happened the other day when I tried to do it to Glare. So I'm just going to tell you now. I'll put a community post up, but hit a notification bell on tomorrow's LV Cops TV show at 1 p.m. because I'm going to be over there. Okay? Tomorrow at 1. Got the notification set. Well done. Thank you, moderators, for keeping it classy today. It is not always easy when we cover Karen's case, Aidan's case, all the cases that people love to hate. Smash the like button on your way out. Also, smash the down like button if you're hate watching, because, engagement, like people do on Twitter. They just leave all those nasty comments up. Well, you can't delete them, I guess, on Twitter. Anyway, thank you, Deborah. Thank you for the happy birthday, belated birthday, Aquarius. This is the dawning of the age of Aquarius. So there's that. You're very welcome. All right, you guys, love you members, love you viewers, replay viewers, smash the like, do all the things that YouTube likes. Tell me your thoughts on this motion. Tell me whether you think what Aidan Kearney's alleged actions are protected under the First Amendment. I happen to think that they are, based on all of the case law that was cited in this motion, and whether this witness intimidation statute is overly broad, whether the things that he did are protected or not protected by the First Amendment. How long will Karen's motion to dismiss be? I don't know, but I'm waiting. I'm waiting on the edge of my seat. As I always say to end every stream, stay cool, stay kind, stay classy. You can do it. I know you can do it. Rise above, my friends, rise above. I'm sure I'll see you at some point very soon. Peace. Happy Valentine's Day.